Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, hear, all persons having business with the Appellate Division draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division, First Department. Today, we have over 6 hours of argument time requested, so as I call the calendar today, please only request the time you need to make your most salient arguments, because I can assure you that this bench has read the briefs and familiar with the underlying issues of your appeals. There may be some who are here for the first time, and if that's the case, the white light on the lectern will go off when you have 2 minutes left, or if you've requested less than 2 minutes, it will go on immediately. And when the light turns red, that means your time is up. If the panel has further questions past your allotted time, they will continue to ask questions, and you will certainly have an opportunity to respond. And certainly the panel wants to welcome a second-year law student from Albany Law School, and her name is Rodrika Gimphy. So that means that everybody must be on their best behavior, because we're training and we want to do things in decency and in order. So with that, when I call your case, please rise and tell us who you represent and how much time that you're requesting. Remember, it's the time that you need and not that you want. With that, People v. Jordan Muldrow. 4-2. 4-2-4. Hernandez v. Bushwick Realty Holdings. 5-5. P. Solani v. Terso B. Okay. There's no one here. Would you like to submit? Okay, so you have 2 minutes. Ostadillo v. Unity Construction. Okay. Uh-huh.
Intervener respondent request 2, Your
All
Honor.
right. 5-2-5-2. Linhard v. Secure, Inc.
For the appellant, 7 and 3, please.
All right. Sure. 5-2-5. People X Rel Burst v. Megley Little. 5-2-3. People v. Troy Harrell. 4-1-4. Drummond v. Associated Test and Balance.
Appellant request 6 and 2. Respondent request 5, Your Honor.
6-6. I don't recall you filing a reply brief, but I'll check that, okay? I'm going to move on. Kim Miguel v. Rosario Ramirez. Submitted. Jeffries LLC v. Mountain State Energy Holdings. Mm-hmm.
5 for respondent, please.
All right, 5-2-5. People v. People v. Phoenix Goings. 5-2-5. Simmon v. Pebble Corp. All right. Three. Thank you. Williams v. Williams. You have it. People v. Casey Urena. Submitted. Castleman v. Interactive Brokers. 525. Marinak v. Marinak. No one is here. I'm assuming you want to address the court. Am I correct? Okay, you have 2 minutes. And Miller v. State of New York, that is submitted. People v. Jordan Muldrow. And Justice Michael is recused.
Good afternoon, Your Honors. Rihanna Isa on behalf of Mr. Jordan Muldrow.
Good afternoon.
At the age of 28, Mr. Muldrow committed his first ever offense. He accepted responsibility, and in the 2 years he was out in the community pending the case, he did not commit another crime nor violate his orders of protections. This offense was an aberration for Mr. Muldrow, and his risk of reoffending is very low. He has a close relationship with his daughter and his mother. He's completed his associate's.
Hold on for 1 minute, please. Please continue. I'll give you an extra minute for that, okay?
Thank you. He's completed his associate's degree with concrete plan to develop a digital game, and he has a long history of.
Didn't he have all those supports in the community at the time he committed this crime?
He did, Your Honors, but at the
And
time
that didn't prevent him from engaging in an act which could have caused an enormous amount of loss of life.
Right. That is correct. This was a very serious crime, but at the time, he had just gotten out of an almost decade-long relationship, and he was under high emotional stress.
I'm sorry, we don't consider that an excuse for engaging in very violent activity.
It's not an excuse, Your Honor, but it's just to explain this aberration, a clear outlier from Mr. Muldrow, where he's not a violent person, he's not a dangerous person. He wasn't dangerous before. Again, no history.
How do we know that he wouldn't be dangerous if he gets in another relationship and it ends badly?
Well, in the 2 years that he was, again, pending the crime, he did not violate his order of protections that he had against his ex-girlfriend. And in the time that he's been serving, he has been getting treatment. He has received anger management treatment, substance abuse treatment, and so you know all of that treatment on top of his already strong pillar, strong foundation will make it so that, again, his risk of reoffending, backed by social science, the fact that he has strong family relationship, he has strong ties,
All of which he had at the time he did.
but
what
now
did.
he has treatment. He has the treatment. Now he has the tools necessary to learn how to cope with stressful relationships or stressful situations in whatever form that they come in.
You know, it seems that we're missing a step, and the reason why I say that, I think we have to address the waiver. And I just want to know, why is it invalid, particularly since, you know, the waiver pretty much tracked the model colloquy. You know, the judge advised that the waiver was, you know, separate and distinct from the right to appeal, explained the waiver process, explained the claims that would survive the appeal waiver. So what went wrong here?
Well, the waiver was invalid because it actually did not track the model colloquy. The model
I said
colloquy
nearly tracked.
nearly, but it missed the one of the core issues that we are arguing makes the waiver invalid is the right to counsel. The right to counsel was not mentioned in the or colloquy. It was mentioned in the waiver, but only in the context of the claims that were waived. And for a person, again, he's never stepped foot in a courtroom, has never encountered the criminal justice system. And appeal waivers are complex for a layperson. And so, considering all of that, he was misadvised with regards to appellate rights. But you know,
Now, the written waiver certainly spelled out the right to appellate counsel, no?
again, only in the context of the rights that were waived. So for a person who's never encountered an appeal waiver, the understanding, the only interpretation that he could get was that his right to appellate counsel was waived. And so because of that, we're arguing that it was invalid. And this court has
to the non-waiver issue in the case. This was the case that the people wanted 10 years on, right?
They did want 10 years, but the plea
And
turned,
he ends up getting 2 1/3 to 7.
which was the max for attempted arson in the third. And which was, for, again, someone who's never committed a crime before, has a strong
And,
foundation.
and they had a pretty compelling case against the defendant, did they not? They had video of him setting the fire, didn't they? And they had
he
video
admitted
of him
guilt.
leaving with the gasoline canister, which had burst into flame.
Again, he accepted responsibility, and we are not here to minimize the crime. Mr. Muldrow understands the seriousness of the crime, but we're asking that he be appropriately sentenced. And the minimum 1 to 3 years appropriately considers both the facts of the case itself, but also he is not a dangerous person.
Do the circumstances of this case make you think that this is a case for a minimum sentence?
It does, Your Honor. It does. A minimum 1 to 3 years is appropriate.
For attempted murder, 4 counts of attempted murder?
He was convicted of attempted arson on the third, and again, because of that, we are
There
arguing
were
that
people asleep in the apartment. I mean, fortunately, the subject of his ire woke up and I suppose woke the others. I mean, otherwise you would have had a bunch of dead people here.
Right, Your Honor. But again, he was convicted of attempted arson. It is a serious crime, and we're not here suggesting otherwise. But we are requesting, that he was harshly sentenced under the facts of the case, both of the things that occurred, as well as, again, he has a low likelihood of reoffending, has been a strong, reliable parent for
He said he got the maximum.
the maximum 2 1/3 to 7.
He just got the maximum of the minimum part of it. The minimum was 1 to 2 1/3 years, and he received 2 1/3 to 7.
He received 2 1/3 to 7. We are requesting that he gets 1 to 3.
Thank you, counsel.
Thank you.
John Cheever for the people. Good afternoon. The defendant validly waived his right to appeal and 2 1/3 to 7 years prison for setting fire to an apartment at 4:30 in the morning with 4 sleeping people in it, including the defendant's ex-girlfriend. Her mother and her 12-year-old autistic sister is not excessive.
Now, I know that, defendant is seeking a reduction and, lack of criminal history, accepting responsibility, employment, but didn't the sentencing court take all of those things into consideration?
Yes, Your Honor. All of that was known. I'll address the waiver first. So the court, as your honors have pointed out, did follow the model colloquy. The only deviation that counsel is complaining of is that the court, in the colloquy on the record, did not tell the defendant he had a right to appellate counsel being appointed, but he brings this appeal with appellate counsel who was appointed from the Legal Aid Society, so that's just a silly argument. The waiver is valid. Additionally, he was on the record saying that he had discussed the waiver and his appellate rights with his attorney, and he signed the written waiver, which would have clarified any ambiguity. With respect to the sentence, the defendant was charged with 4 counts of attempted murder in the second degree, and each of those carried a potential penalty of up to 25 years for trying to burn his girlfriend and her family alive. Instead, he walks out with 2 1/3 to 7 years for attempted arson in the third degree, which is extraordinarily lenient. I also want to mention that the defendant is now out on parole.
He is actually facing a sentence of 50 years.
Yeah, I believe that's correct, Your Honor. That's what they said, yes. If he had been, the people were originally seeking consecutive time. Your Honor mentioned 10 years. That was actually the first of 2 offers. The first offer was 10 years, but originally they were seeking consecutive time. But because, in light of the fact that the defendant is out on parole, his arguments for developing his video game and seeking whatever life opportunities he wants are largely academic. The question is whether he should remain on parole, which he obviously should. And if he wants to reduce his time on parole under the Less is More Act, he can lead a law-abiding life and abide the orders of protection in this case. Unless Your Honors have questions, the people ask that you affirm.
Okay, thank you.
I'd just like to make two quick points. With regards to whether or not the sentencing court has addressed the factors, that is always true, right? In your broad and plenary power, in interest of justice power to reduce excessive sentence, that necessarily has to be true. Anything that the court did not consider is outside the record. So just to kind of put that. And then also the fact that I'm here is irrelevant to whether or not the actual waiver was valid.
Its written waiver addressed the availability of appellate counsel, correct?
But again, only in the context of only in the context of the claims that are waived. And so, if the only way that Mr. Muldrow had understood and heard about his right to appellate counsel is in the rights that were waived, a layperson to understand a complex waiver will only understand that as being that will also be waived. And so we're arguing.
But he was told that if he could not afford the cost of a lawyer, the state would provide a lawyer for him.
But again, in the context of the rights that were waived, not in, so this is different than the model colloquy that mentions it broadly and then separates sort of the claims that are waived versus not waived. Right here, it was only mentioned in, again, the context of the rights that were waived.
Now, counsel, during the colloquy, the defendant repeatedly advised the court when questioned that he understood, right?
He understood the waiver, sure, but again, in terms of making
No,
sure that,
I get your argument.
Yeah.
Now, at any time during the colloquy, did either trial counsel or defendant say, Judge, we don't understand, can you go over this again? We need to clarify it. Did that ever happen on the record?
I mean, it wasn't mentioned, so he wasn't signified or flagged to be like, oh, just to clarify, is this right waived or not waived? Is this part of the claims are waived or not waived?
And your client has an associate's degree, correct?
He has an associate's
He's
degree.
not
in
a
family.
totally uneducated person.
He is, but again, this is complex. I mean, even for a lawyer, it's complex.
But he certainly has enough education to know that when the judge says, do you have any questions, that the response is, if he has a question, he can ask it.
But if he's not flagged to or indicated or, sort of, again, if it wasn't mentioned at all, how is he to know that this is a question to ask?
And he had counsel.
He had counsel, but that doesn't delegate from, the court has its own duty to make sure that the waiver was knowingly, intelligently, and that can't be delegated.
Thank you so much. Thank
Thank you,
you.
Your Honors.
Hernandez v. Bushwick Realty Holdings.
You just have to turn on your mic.
All right.
Good afternoon, Your Honors. May it please the Court, Brendan Fitzpatrick, counsel for the Appellate Capital Concrete. Your Honors, I ask the Court to reverse the Supreme Court's decision that granted plaintiff summary judgment on the issue of Labor Law Section 240. While we submit that there is sufficient evidence to support the dismissal of plaintiff's actions at plaintiff's complaint because his actions were the sole proximate cause, at the very least, when when capital and the defendants are given the benefit of every inference, issues of fact and credibility are raised as to whether any violation existed and to whether plaintiff's actions were the sole proximate cause of the accident. The court,
What evidence is there that, plaintiff is the sole proximate cause?
first, there's no defect with the ladder. Plaintiff testified that it was secured at the top and the bottom. There's no,
But there's no expert testimony about this particular ladder, correct?
yes, there is.
That was, the expert examined it a long time later, right?
Then she reviewed the pictures that plaintiff said represented the ladder.
But she didn't actually review the actual ladder, right?
No, because the accident was,
But, I mean, we don't need a because, we just need to know what she reviewed.
she reviewed the photograph and the testimony that the ladder was secured at the top and the bottom.
Okay.
Plaintiff admitted that.
Now here, the ladder shifted without any explanation. Now, that's a, prima facie showing of liability. The ladder shifted. Plaintiff said that repeatedly. The ladder shifted. So let's just take this scenario. Let's assume plaintiff, establish prima facie. Let's just assume it. How did your client raise a tribal issue of fact?
One plaintiff's testimony raises an issue of fact as to whether he was misusing the ladder, whether he was going down in a normal way,
But wouldn't that be
Doesn't matter.
contributory negligence?
No, Your Honor, I think the Second Department's decision in Anderson, that issue as to whether plaintiff was going down the ladder, basically as you would go down a flight of stairs, was given to the jury.
I
Is
think,
there any evidence that he was told that there was a right way and a wrong way to go down a ladder?
Your Honor, there's no
In
testimony.
the
as to-
absence of evidence that he was told that there was a right way and a wrong way to go down, how are we to conclude that he was going down the wrong way?
He testified repeatedly that he was trained in how to use ladders. He said
Counsel, you referenced the case Anderson. Aren't the facts of Anderson significantly distinguishable than the facts here? In that case, you had someone going down a ladder, holding a cup of coffee and a donut.
Yes, he was basically using a closed A-frame ladder that had been placed on unstable ground, basically using it as a set of stairs. Here we have plaintiff may not have been holding anything in his hands, but he did testify that he was going down the wrong way down a ladder. That, according to Ms. Osterholt, that is a misuse of the ladder. And she
That was a misuse. That's comparative negligence, which is not a defense to a labor law 240. But let's talk about the stairs, because I know that you're saying, he should have used the stairs, right? That was another way to gain access. What evidence did you put forward that he was instructed, use the stairs?
Well, Your Honor, I think the line of cases from this court and the Court of Appeals in Montgomery, there was no specific direction in Montgomery that plaintiff use available ladders. This court said the normal and logical response would have been to use those ladders.
He was never told not to use the ladder.
No, Your Honor.
There's no evidence in the record that he was told not to use the ladder, right?
No, there
And
is
there's no evidence in the record that he was ever told to use the stairs, correct?
no, Your Honor.
the stairs were newly built, correct?
They were there, yes. There's no debate that they
They
were
were
there.
just, I mean, this was part of the work. The stairs were part of the whole construction.
Yes, they were, Your Honor.
And
So-
counsel, back to Montgomery, again, you cite to a case that's distinguishable. In Montgomery, you had a plaintiff who was using a bucket to get up and down.
Yes.
Versus a person here who was actually using the ladder.
Right. In Montgomery, plaintiff was also following his supervisor. His supervisor was the one.
Testified two different ways as to how he used this ladder, right? One time he said he went down the right way, and the other time he said then he went down facing away from the
Yes.
rungs, right?
Yes, Your Honor, I believe that's a question of fact. One, because this is unwitnessed and now plaintiff's credibility
It
is.
doesn't matter if the ladder shifted, right? Because then the ladder was not effective in being an effective safety device because it moved.
Again, Your Honor, I think you're talking about whether this was secured or not. Plaintiff testified that it was secured at the top and it was secured at the bottom.
But nonetheless, it shifted. And that's the evidence that we have before us. We don't have anything else outside of that,
Our
right?
expert opined without debate that the ladder, when it's secured at the top and bottom, could not have shifted.
Your expert opined on a ladder that she didn't actually physically view.
Your Honor, we couldn't have
You
reviewed
can
it
talk
because it was
about
never
that
reported.
on rebuttal. You can follow up on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the Court, Jonathan D. Moran for the respondent. Briefly, Your Honors.
Do you need anyone to tell you that you don't walk down a ladder facing away from the rungs?
Well, there is certainly no evidence here that plaintiff was instructed to walk facing away from the rungs or facing the rungs.
Is that something that one needs to be instructed about, how to walk down a ladder?
For purposes of the labor law and purposes of this case, I think no, because that did not, there's no,
Isn't the hazard of walking down a ladder facing away from the rungs just something which stares you in the face? What are you holding on? What are you holding on to if you're walking facing away from the rungs?
well, even assuming if you look at the picture on, I think it's on page 1345 of the record, it kind of looks like stairs, but irrespective of whether or not that is something that should be obvious to a layperson, there's no evidence on this record that him doing so caused the ladder to shift. There is no evidence that even if it is a misuse, that's anything other than comparative fault, which is not a defense to the presumption that's created by the shifting of the ladder that Labor Law 240 sub 1 was violated. So like the Hox-Hodge case and Sanchez v. 1 Burgess Road, even assuming that he was facing away from the rungs and even assuming that that was not the proper way to descend the ladder, a Labor Law 240 sub 1 violation would nonetheless exist. For instance, in Hox-Hodge, the plaintiff had 1 foot on the top cap of the ladder and 1 foot on the rung below, and that's and the ladder shifted. But nonetheless, because the ladder shifted and because there was no evidence linking that purported misuse of the device to the shifting of the ladder, Labor Law 240 sub 1 was found to be violated.
Counsel, to a question I was asking your adversary regarding Montgomery, is that case not distinguishable from the case that we have here?
It is absolutely distinguishable, as is Anderson. Montgomery did not involve anything closely resembling the facts of this case. And in Anderson, which did involve a ladder, the ladder in Anderson didn't move. And that was precisely the holding in the second Anderson ruling, which after trial, the decision cited the fact that there was no evidence that the ladder shifted. That's the crux of a 240 sub 1 violation.
And the plaintiff in that, and Anderson, had not testified to the ladder shifting, right?
Exactly right, Your Honor. Exactly right. There was no evidence on this record that he was instructed to use some other device. There was no evidence in this record that he was instructed to not use the ladder that he was on. There was no inspection of the subject ladder in this case. There is nothing to refute the fact that the ladder shifted as my client testified that it did. Unless the court has any other questions, I'm happy to rest on my briefs.
All right, thank you.
Thank you, Your Honors.
The ladder wasn't expected because not only was this accident unwitnessed, it was never reported. We had no ability. YNH never received notice of this incident until it received the complaint.
Counsel, Justice Michael, do you want to address counsel?
No, I'm fine, thank you.
Okay. I want to go back to Montgomery because in Montgomery, it was clear that the plaintiff disregarded a readily available safety device. So my question to you is, what evidence did you put forth that the plaintiff here was aware that he was expected to use the staircase as opposed to the ladder?
I believe Ms. Ulsterholt attested that the ladder was clearly visible, it was there to be used, and that, again, it wasn't my strongest argument, Your Honor, but when there's evidence of an available safety device that can be used, Montgomery says it should be used. Now, again, I submit that the ladder that plaintiff used—
Knowingly, but I've yet to hear in your answer that there was evidence that this plaintiff was instructed to use the staircase. That's not what we have in Montgomery.
Montgomery, he was never directed to use the available safety device. This court said the normal and logical response, and the Court of Appeals affirmed that, was to use that.
What was what evidence is there that, if you're saying that the available safety device was the stairs, what evidence is there that he was aware of that?
Your Honor, again, it's because this is unwitnessed, because it was never reported.
No, but
Again, Your Honor,
it's on that job site, what evidence is there that he knew about that stairway?
Because
or
it-
that he was ever told about it specifically?
according to Ms. Ulsterholt, it was visible. It was there for him to be seen.
Actually, that was later on, because when he started with the job, I think the ladder was the only access he could have to go to get the materials that he needed.
And he was there for 4 months, Your Honor. But again, if I can brief—
Again, so the stairs could have been built maybe during that time. It's a new set of stairs, then he may not be aware that it was done, or he's not allowed to use it just yet. We have no idea.
Your Honor, it's an unwitnessed, unreported incident. Justice Michelle, if I could just briefly talk
Michael,
about—
Justice Michael.
Michael, I'm sorry, about the ladder, why it wasn't inspected. It wasn't inspected because we were never told of the incident. But plaintiff testified that the ladder was secured. Mr. Spinella, he testified that the ladder was secured at the top and the bottom.
But the problem with the jurisprudence in this department, not that it's a problem, but the problem that you have with the jurisprudence is that because he's testified to it shifting, regardless of who said that it was secure, we have a shifting, moving ladder and a falling worker.
And Ms. Osterholt opined without debate that the ladder could not have shifted as plaintiff alleged because it was secured securely to the top and at the bottom. She attested without debate that it could not have moved like that.
Thank you.
Thank you, Your Honors.
Matter of Solani P.
Good afternoon, Your Honors, and may it please the Court. My name is Rebecca Half, and I represent the child who is the subject of these proceedings. At the time the order now on appeal was entered in this case in February 2025, the child was 10 years old and had resided with the father in Pennsylvania since he was approximately 2.5 years old. Despite the father's efforts to support the mother's relationship with the child, the mother had maintained only sporadic contact with the child for approximately 4 years and had wholly absented herself from the child's life numerous times for periods as long as a full year. She saw the child just once during the 4-year and 5-month period between the entry of the 2020 order and this order at a supervised visit that took place during the hearing and went poorly. As a result, as the court correctly concluded, the child had no real relationship with the mother and wanted no contact with her, as he had been disappointed many times and felt rejected and defeated. Although the mother herself admitted that her phone calls to the child had been few and far between for years, her testimony revealed that she had extremely limited insight into the impact of her conduct on the child and took no responsibility for the deterioration of that relationship, instead blaming the father. Nevertheless, the family court expanded rather than contracted the mother's access to the child by modifying the 2020 order to grant her 3 forms of visitation, none of which were contingent on the father's approval or discretion. Supervised visits with the child once every 2 months in person, 2 hours of virtual contact every week, and family therapy virtually if she was able to arrange it.
Now, there were times when the child would expect the mother to call and she did not call, or times when the child would call and the mother would not answer the phone.
That's correct, Your Honor. So even setting aside the court's credibility determination, which was clearly correct, the child himself reported that he had tried to get in contact with the mother and she was unresponsive for months at a time. The order robustly protected the mother's rights. It gave her a great deal more than what the prior order in 2020 granted her and allowed her to rebuild her relationship with the child if she committed herself to it.
Thank you so much.
Thank you.
Thank you. Ostadillo v. Unity Construction.
Good afternoon, Your Honors. My name is C. Briggs Johnson, and I'm here on behalf of the Appellate Arsenal. So the purpose of our appeal, I think I want to make clear, is not about counterclaims for fraud. It's not about asserting claims for fraud against anyone. It's about the rules of professional conduct and how this law firm that walked away from 200 cases.
When the law firm made a motion to be relieved, did you respond?
We did not at that time, no.
So
Why not?
Because at the time we were still gathering the information regarding this whole 200 caseload that they were walking away from based on fraud with the referral process. So
And just so that I'm clear, it's
Yes.
fraud within the referral process, right?
That's what we see right now. That's what they admitted to on the record. And so, we don't have issue with the firm walking away from the case per se if they want to be relieved, but we have issue
They
with
may have been a victim of that fraud too. Is that possible?
Excuse me?
Is it possible that they're a victim of that fraud too?
That's also possible, but we don't really know.
We don't know that. We don't know one way or the other.
We don't know, but
But what we do know is that we're not talking about any fraud on behalf of the plaintiff, right?
we don't know that either. I think if you walk,
There's no evidence of that in the record at this point, correct?
there's no evidence of fraud right here, right now that we know of. Correct.
So no, there's no evidence of it.
No, but I think you're right. I think when you say on the record that you have 200 cases that are not necessarily fraudulent,
That's not our record.
Right.
But-
And that has nothing to do with this plaintiff.
And that's in the federal court, isn't it?
say that again. I'm sorry.
Isn't that in the federal court?
The RICO actions in
RICO
federal
case?
court? Yeah, those are in the federal courts.
Okay.
But I guess the point I'm trying to make is it could be this case too. We just don't know.
Well, but it could be this is really not an appropriate basis for a motion. It seems to me if you did discovery, it's quite possible that it would show up that there was no accident or there was no injury or something like that. But here, in the absence of any evidence, how can we undertake this? You asked for 6 or 7 or 8 forms of relief. How would that be appropriate where there's no actual evidence of any fraud in this case.
I think it can be implied based on the way they withdrew from the case, because they
What can
were
be implied? Fraud?
implied that they may have filed a false pleading or an inaccurate
Based
pleading
on what?
based on the way they withdrew from the case.
So we would have to go on a witch hunt?
No, they would have to come into court based on how the rules of professional conduct were amended in 2009 and say, this is what actually happened here. And
He
then
didn't even move for leave to be relieved of the case because there was a substitution of counsel. So I don't even see, I have greatest deference to the rules of professional discipline, but I don't understand why, if he was substituted for, how those would even come into play.
well, I guess what I'm trying to say here, and I may not be making this as clear as you want me to, so I apologize for that. When you say on the record that there's 200 cases that may have fraud on it, right? And then you move
That's not this record.
No, but this is one of the cases that they withdrew from. That's what I'm trying to say.
So now
This
there's
is one of the 200
discovery
cases.
going on now. There's discovery going on now in the case, right?
Correct.
Okay, so in the discovery, were there any questions posed? Because there's depositions, right? There's been
There's
depositions?
depositions. The case is still ongoing.
Okay, so any questions about how Subin was retained? Any questions about that?
That has not been asked at the depositions. No.
Why not?
It's a great question.
Great. So let me see if I can ask another great question. So were there any questions in the deposition about how the accident happened?
Yes, there were. I'm sure there were, Your Honor.
You're sure there were, or
Yes,
you know?
yes,
Yeah.
they were. They were. Yes.
So anything about the discovery process that says, you know what, there's some fraud here. Can you say that?
Well, Your Honor,
That's
you
usually
can
a
ask
yes
that question.
or no. That you know.
Yes. Yes.
Okay,
But
what?
But who's going to admit to that? Who's going to say, yeah, this is fraud?
What's the evidence? No, I'm saying, what is the evidence? Because, you know.
You said yes, that there was some link, some evidence. When we said, well, what was that link? Now you're saying who's going to admit to the link?
No. I'm saying based on the admission of fraud in the referral process, and that they withdrew from 200 cases that had that they thought might have fraud in the referral process. This was one of those cases.
There was no admission to it.
There's no admissions.
There's no admission to there being fraud in the referral process in this case, correct?
There's no admission on the record. No.
Okay.
My argument.
But is there anything that you've seen in discovery that suggests fraud in any way in terms of the treatment or how the accident occurred?
Not as of this moment. Not as
Thank
of this
you,
moment.
thank you.
Good afternoon. May it please the court. I represent the plaintiff respondent. I mean, the court nailed it on the head. There is not one single solitary shred of evidence that there's any fraud in my client's case. The case is now on the trial calendar. We've gone through the entire process of discovery. I made this point a few times in my brief. I'm not trying to throw around words of, the only misrepresentation that appears to have happened here is in Arsenal's own incident reports, where they basically tried to say that my client suffered a phantom pre-existing injury. Then they tried to claim that there were two witnesses who admitted under deposition that they never actually saw what happened. They weren't even looking in the guy's direction. I mean, the bottom line is they have not presented.
Excuse me, is that in the record that we have?
It was from the record from the prior, the motion to stay that was denied.
Okay, could you stick to the record that's
Yes.
before us?
Right.
It
And-
applies to you as well as to opposing counsel.
Understood, Your Honor. Well, then there's nothing in this record whatsoever that shows fraud regarding my client.
Any questions, anything else? All right. Thank you.
Thank you very much.
Good afternoon, Your Honors. Brian Isaac. I represent the intervener. I'm sure you're going to be happy. I'm going to be very brief, but I did want to read something from Mr. Johnson's brief. Terrific lawyer, but I think it's important. Page 6, word for word. And to be crystal clear, defendants are not seeking sanctions or asserting claims of fraud against Subin. What defendants are seeking is something different. Defendants are seeking an appropriate and reasonably tailored investigation into the fraud, et cetera. He said there's no fraud. And listen, I get it, but the appellate division isn't the grievance committee. You have a procedure that's set up. And I did want to point out one other thing, and then I'll sit down. You're appealing from a trial court's order. The trial court has no jurisdiction over judiciary law matters. You do under Section 90. The trial court doesn't. So why are you appealing? Yes, there are a lot of things I'd like courts to do, but you have to follow the rules. And there's nothing here with fraud based on defendant's brief. That's word for word what I read. Thanks for listening to me.
Thank you.
Your Honors, unless you have any further questions, I'm going to rest on the arguments in my briefs.
Okay.
Thank you.
Thank you. Leanhart v. Secure, and Justice Chan is recused from that matter.
Good afternoon, Your Honors. Ephraim McDowell, representing the Secure defendants' appellants.
Good afternoon.
The trial court erred by refusing to enforce clear contractual provisions executed by sophisticated parties in an arm's-length transaction. And it also independently erred by allowing plaintiffs' fraud claims to proceed even after the statute of limitations had expired. In 2018, Plaintiff Appellee, the former CEO of Secure, agreed to settle potential fraud and defamation claims against the company and to sell back his remaining shares. In exchange for a payout, plaintiff agreed to release the defendants from, quote, any and all claims, whether known or unknown, and he agreed that he had all the information he needed to enter into the transaction and that he was not relying on the company. Nonetheless, over 6 years later, plaintiff regretted selling his shares, so he brought this case, raising the same basic fraud claim that he had already settled. This suit is plainly barred by plaintiff's express release of claims and by his disclaimer of reliance. This court and the Court of Appeals in cases like...
Ambiguity about those provisions?
Sorry, Your
Is
Honor?
there any ambiguity about those provisions?
Not at all, Your Honor. And I would just point the court to page 258 for the text of the release, which says, quote, any and all claims, whether known or unknown, were released. And then on top of that, there's another provision directly under that saying that he expressly waives unknown claims. So that includes fraud claims that may have come to his awareness later in time. As for the anti-reliance provisions...
And he knew he hadn't received all the records, right?
He did know he had not received the records or the capitalization table, and I think that cuts in our favor, because if you look at cases like Centro, what the Court of Appeals there said is when a plaintiff, a sophisticated plaintiff like this one, asks for records, doesn't receive them, they're then on notice.
He goes forward anyhow.
Excuse me?
He goes forward anyhow.
Exactly.
He agrees to that settlement agreement, even though he knows that their records they're holding back.
Exactly, Your Honor, and that is pretty much on all fours with Centro, as well as this court's 2021 decision in Silver Point. In both of those cases, the plaintiffs were sophisticated parties. They asked the defendants for records about the company's value or share value. The company did not provide those, and instead of bargaining for additional contractual protections, or instead of declining to settle until they got that information, they entered those agreements with their eyes wide open. And the same thing occurred here. There's no basis in our view for distinguishing either Centro or Silver Point. The trial court invoked the special facts doctrine as the only way of getting around this release, but the trial court and the plaintiff have not cited a single case from any court applying the special facts doctrine to override a clear release or anti-reliance disclaimer. And in Silver Point, there was an argument under the special facts doctrine in that case, and this court squarely rejected it. That's in the Silver Point opinion, and we don't see how you can get around Silver Point. And that makes sense because as the Court of Appeals explained in Centro, releases are designed to establish finality for defendants. You're allowed to release unknown fraud claims. We know that from Centro. And for that to have any meaning, the special facts doctrine cannot apply as expansively as the trial court applied it here. And before my time is up, I also want to briefly speak to the statute of limitations, because that is an independent problem with this lawsuit. The last alleged act of fraud occurred in February 2018, just before the agreements were signed. Plaintiff did not bring the lawsuit until October 2024. So that's over 6 years after the alleged act of fraud. That establishes our prima facie case of the statute of limitations expiring. The plaintiff would then have to come forward under the well-established burden-shifting framework and show why the discovery exception applies. But the trial court here put the burden on us to show that the discovery exception didn't apply. That's never been the way that the burden shifting framework has worked. There's no precedent for that. But even setting that aside, we know from the complaint and the plaintiff's own allegations that the plaintiff had actual notice of this supposed fraud dating back to 2017, 7 years before the plaintiff filed suit. So on the complaint's own allegations, there would be no basis for applying the discovery exception.
Thank you.
Good afternoon, Your Honors. May it please the court, my name is Deborah Messier, and I represent the plaintiff respondent Bradley Leinhart in this matter. Your Honors, there are two hurdles the appellants have to surmount here in this case. Number one, this court has said many times that it disfavors interlocutory appeals, and secondly, the standard of review, frankly, Your Honors. I mean, this is a pre-answer motion to dismiss. My client deserves his day in court, and there's been a
What does that matter if we have clear provisions before us?
Your Honor, I don't believe that they are clear provisions, and I'd like to make...
A release
Yes, Your Honor.
isn't a clear provision?
I'm sorry,
A release?
Justice Friedman?
A release isn't a...
Well, as the trial court correctly decided, the release is trumped, if you will, by the discovery of fraud after the signing of the release and separate frauds. In this case, we have significant fraud in
Doesn't
this
that
case.
fraud relate to records that he knew he hadn't received?
Actually not, Your Honor, respectfully. It is not solely related to the disclosure of the cap table. It is specifically related to the discovery by my client in 2024 in federal litigation that the defendants had executed a secret omnibus incentive program, which they then presented to Judge Woods in the federal case. However, they had not made my client aware of it. It's substantially diluted, shall we say.
Was that document allegedly available back when he signed the release?
No, Your Honor, it was completely concealed
Just
by
wanna
the
go back.
defendants.
You're talking about the omnibus incentive plan.
Yes, ma'am.
Now, that was done what, like January 2013?
I believe so, Your Honor. However,
I'm going somewhere
Okay.
with this. Okay. So, but the settlement agreement, that was done in June of 2013. The settlement agreement.
Yes, Your Honor.
Okay, so stay with me. We got January, the omnibus plan. The settlement agreement, June 2013, releases claims known and unknown. So that would cover January, right?
Your Honor, respectfully, I disagree.
Okay, that's fine.
And let me tell you why.
But one thing, I don't think we're gonna disagree on this. Your complaint, does it allege that the 2013 settlement was procured by fraud? Does it?
We did not.
No. The 2013.
did not address it, Your Honor.
I'm still speaking.
Yes, Your Honor.
2013 settlement agreement did not allege fraud. That's a yes or no. It either did or it did not. I don't think it did. Did it?
I believe that the general allegations of fraud cover their actions in
No. Let's not skirt around this. The 2013 settlement agreement. It's not alleged that that was procured by fraud. The 2013 settlement agreement. That's what I'm talking about.
Your Honor, respectfully, I disagree. I believe it's incorporated
Maybe you
in the
can
general...
refer me to the paragraph, but I'm gonna move on because to me, the 2013 settlement agreement is not alleged that it was procured by fraud. We have a January agreement, the omnibus incentive plan made January 15th, 2013, and then June 21st, 2013, we have that settlement releasing all claims, known or unknown, arising on or prior to the date of the release.
Your Honor...
So how do we get around that?
Your Honor, that would be true. I'm not asking to get around it. I'm just giving you the facts. Your Honor, that would be true if the 2013 omnibus incentive program was a legitimate document. There's questions as to that, and the trial court
referenced that in her decision, there was a document provided to Judge Woods in the federal court, the Omnibus Incentive Program. Then there was an entirely separate document, and it was, by the way, hidden from my client, so I don't know how he would know about it if it was completely concealed. It was also concealed from other board members, Mr. Philip Aton, other people they allege had notice of it. There's a second version, shall we say, of the Omnibus Incentive Program that was presented to Judge Patel during the trial portion here in the motion to dismiss briefing. Completely different than the document presented to Judge Woods. So we're not sure that that document was not manufactured subsequently after 2013 in response to the 2024 federal litigation. Thank you, counsel. Thank you.
Thank you, Your Honors. 3 quick points. So on the Omnibus Incentive Plan, Your Honor, you're exactly right that that was signed and adopted in January of 2013. There's then the 2013 settlement agreement that releases any and all claims, whether known or unknown.
Well, what your adversary just said is that we don't actually know when that was created based on all of the fraud percolating in the case.
Well, respectfully, Your Honor, even if that were true, which is not, and I'll get to that in a second, the release still applies because it applies to any and all claims, whether known or unknown. But it's also just incorrect, and I'd point Your Honors to page 624 of the appellate record. That is a document of the board resolution adopting the Omnibus Incentive Plan, and plaintiff's signature is on that document. He was a member of the board of directors. He was part of the adoption of that plan, so he did know about it. But
how does the portion of the agreement which indicates that the plaintiff was not relying on any information from you guys to make a decision to sell, how does that play into the analysis?
Your Honor, that provision is independently dispositive of their claims, even apart from the release. This is at 291 to 292 of the record. That's an anti-reliance disclaimer. And in case after case, from Centro to LLM Capital to Silver Point, this court and the Court of Appeals have enforced those disclaimers, and they've held that when you sign a disclaimer like that, you can't show justifiable reliance at that point. And that's an indispensable element of your fraud claim. So the fraud claim has to be dismissed on that basis as well. And we make both independent arguments in our brief, both the anti-reliance disclaimer argument and the release argument. And I think that brings me to the separate fraud argument that my other side, my adversary, was speaking about. That separate fraud doctrine does not apply here because all of the fraud claims at issue here fall squarely within the broad and comprehensive terms of the release. They are not somehow separate from the release. To show that they would be separate from the release, the plaintiff would have to argue that the release itself was induced by fraud.
Thank you. People, X-Rel Burse.
Good afternoon, may it please the court. Dorothy Weldon, New York County Defender Services for petitioner appellant Jamie Beltran. After correctly granting Mr. Beltran's habeas petition, the writ court erred when it refused to release Mr. Beltran and remitted, his criminal matter for further proceedings. The writ court's decision must be reversed with respect to remedy. Now, to begin.
What did the writ court do? The writ court sent this matter back to the original court to make the necessary calculations.
To hold a hearing, but I think.
To hold a hearing to make the necessary calculations in terms of time, right?
Yes.
Which is what your client wanted, right?
My client wanted
an adjudication on the amount of 30-30 time that had elapsed.
That's partially what Mr. Beltran wanted, but what Mr. Beltran was entitled to was release because, and let me just hammer this point down. What the writ court found was that the record from the bail setting court was quote unquote incomplete and that the court failed to hold this appropriate full hearing. Now, in the context of speedy trial, a finding that the record is incomplete is synonymous with a finding that critical burdens by the prosecution were not met.
The record was incomplete with regard to the court's finding, not with regard to what the parties established, right? Because the court didn't permit a calculation date by date. That's what the writ court found.
The writ court found that the record was incomplete as to both. If the court didn't permit anyone to make a record as to that, it was defense counsel who was not permitted to make that record. It is the people's
Well, no.
burden.
Defense counsel was told to put his arguments in writing, which he refused, right?
Right. So he is entitled under 3030 sub 8 to make oral applications for speedy trial release. Now, under
The speedy trial calculations were actually done after, right?
You mean, were they done in the writ court or
Yes.
later on?
Later on.
Well, certainly they were argued, right? And Judge Bybin refused to make a finding as to the math, right? And that was one of
That's
the
why
reasons she sent it
remanded?
back.
That's why she sent it back to the 3030 court to get that.
That's certainly what she said, right? But what she found by sending it back, right, the writ court is essentially saying, and she's saying this quite literally, that there were huge gaping holes in the record that was sent to her from
Where
the
did she
bail-setting
literally
court.
say that in the record?
Sorry?
Where did she literally say that in the record?
She said at the record at 67 that the record is incomplete, right? And that she doesn't have sufficient information.
Okay, so
to make these
that's not huge gaping holes, right?
I would say in the speedy trial context, it is. It is the prosecution's burden to make the record clear in the first instance and to prove excludable time. Again, the fact that the record is incomplete and the fact that Judge Bybin is granting this petition on that basis is synonymous with a finding that these burdens were not met. No matter how you slice it, Judge Bybin acknowledged in her ruling that the law was not complied with. That's why she sent it back, right? And because of that, Mr. Beltran's release is required. Now, it was required both under speedy trial law, which of course I've just stated, right? These are very strict and bright line rules. When
The finding had been made that they'd been violated. The only finding had been made was that the record was incomplete in order to make a finding. But there was no finding that the speedy trial rules had been violated, correct?
Well, Your Honor, in speedy trial law, when the record is incomplete, whose job is it to make that complete record? It's the prosecution's burden to do that. If the writ court is analyzing a record and saying, I don't have the information.
Just so that I understand, right, where the judge is not permitting or did not permit for there to be a hearing, right, the prosecutor has to yell out, stop the proceedings, and then start to put dates and their readiness on the record?
Well, the prosecutor has to do certainly more than they did. And yes, it's their job to make that record clear in the first instance.
When given an opportunity to do so.
They didn't make any effort to do so. It was defense counsel who was making an effort to make these arguments, who was shut down by the bail-setting judge. And the people did not meet their burden to make that record clear in the first instance.
Is there any case law that puts an affirmative burden on the prosecutor in that situation to say, Judge, I want you to address these periods of time?
That's the heart of speedy trial law, period, right? It's the prosecution's burden to make clear records in the first instance.
So the writ judge was sending it down just to get a record, to correct that gaping hole, as you say.
That defeats, it's sort of an end run around speedy trial law, because when there is that error, that gaping hole, it means that the prosecution failed to put enough out there to make that record complete.
And what that means is that they weren't given an opportunity to make a record, just as defense counsel wasn't. And so the judge sent it back to the 3030 court so the record could be made. That's what that means.
I'll disagree, but I'll
You
come
can
back
talk
on rebuttal.
more on rebuttal. Okay, all right.
Good afternoon, Your Honors. Christian Rose for the people. I just want
Counsel, why didn't the people interrupt the proceedings and demand to be permitted to place your readiness for particular dates on the record?
Well, one, that's not our burden, and two, I think it's important to note why this hearing occurred the way that it did is because defense counsel asked to advance the case in order to make a bail application. Then, as this is right, stated at when the parties convened that they were actually going to make this complicated 3030 release claim with no transcripts or records to support the claim. The judge bends over backwards to allow defense counsel to make whatever arguments they can.
Well, it's not bending over backwards, right, if you're following the procedure of the 3030 law.
No, because the court was fully entitled to request that any arguments be made in writing with notice so that the proper records can be provided. I mean, the 3030 law doesn't allows for oral applications to be made, but not that the hearing occurs immediately because the required records aren't there. That's what the habeas court was saying when it said that the record was incomplete. Because almost 3 weeks later, then the petitioner files a habeas petition with all of the transcripts, all of the written arguments, all of the actual charged dates, none of which had been actually given to the original court. And so that's why the habeas court says that the record is incomplete, because it's incapable with the record that was available that was actually made to Judge Lewis to make the 30-30 calculations. And
But my point is that technically whenever you hear a bail application coming, you know potentially that there will be some sort of 30-30 release application that comes along with that, right?
I guess it's possible, but when you're going to make a claim, a complex claim that relies on all of these minutes from this case that's been going on for quite some time, and the judge isn't allowed to have these minutes, asked if the defense attorney wants to have papers and written that day for the people to respond within a week, and that they'll advance the case if they think that dismissal is necessary. That's the judge doing everything that they were required to do in order to hear this application. And I'll just note that the CPLR only permits release upon a finding that the petitioner is legally detained, and here the habeas court explicitly found that the petitioner was not illegally detained on the record before it. And in fact, when it's sent back with a full hearing that same day, by the way, then the court found that there were only, I think, 8 days chargeable to the people. And so, unless there are any other questions.
And it was the ability to make that finding was because the minutes were available in terms of who stated what and who requested what time, right?
That and the fact that the defense attorney was able to go in and actually say these are the actual periods that I'm challenging, which had not been suggested to the trial court. I mean, I think it's even worth noting that at the habeas petition, there were periods that were challenged as chargeable to the people for the habeas court that occurred after the trial court's decision. And if there are no other questions, we just ask that the appeal be dismissed and otherwise that the order be affirmed.
Thank you.
Just briefly, clearly, the bail setting court did not do everything it was required to do, as respondents just argued. That's why this matter was sent back. Now, once defense counsel, under speedy trial law, says that more than 90 days have passed, it is then the people's burden to prove excludable time and to make a clear record, which they made, respectfully, no effort to do. More than that, neither of these remedies, continuing Mr. Beltran's detention or remitting this back to the bail setting.
So what's the relief that you're requesting right now?
We're requesting, number one, of course, that Mr. Beltran be released, that subsequent
Even though there was a finding that there was no 30-30 violation?
Yes, and that's because the subsequent proceedings stemmed from an unlawful order of the writ judge and should be vacated, and Mr. Beltran should be released. Every single day of prolonged pretrial detention needs to be justified under law, and because Mr. Beltran's was not, as the habeas court found, his release was required. Thank you.
All right, thank you. People v. Troy Harrell.
Good afternoon, Your Honors. May it please the Court. Elizabeth Lagerfeld for Mr. Troy Harrell. The prosecution did not meet its burden to prove an inventory exception to the warrant requirement in this case. And I want to be clear that the inventory exception turns on the actual purpose of the search that produced the cocaine in this case. So even if they cataloged every toothpick on the floor mats of this car, it is not an inventory search if that cataloging was a pretext to look for contraband. And that's exactly what we have here, an pretextual after-the-fact cataloging of property.
Well, didn't the police have reason to stop the car?
Yes, Your Honor. So we're talking about the search that produced the cocaine.
And the search that followed was just in line with what the police would do after defendant's arrest.
As an inventory search.
An inventory search where to safeguard the property, also the police.
Respectfully, Your Honor, this inventory search was not done to safeguard property, and more importantly, the officer's own memo book indicated that he actually found the cocaine on scene before.
So let's go back.
Sure,
And
Your Honor.
Can you address why the inventory search, didn't meet the criteria based upon the applicable law? Let's do that. Why didn't it meet the criteria? Because we know what the criteria is and what fell short here.
Yes, Your Honor. So there's no way to make this sole witness's testimony as to the purpose and timing of the search make sense and come together. So he says, when asked, why did you perform an inventory search? Why did you voucher a car, for a false personation arrest? He said, I vouchered the car because of the drugs. Now, the people say all that he means by that is I kept the car itself after the proper inventory search because I had found drugs. The problem with that is that a few lines down the transcript, he testifies to the opposite. He says he had decided to keep the car already based on the false personation arrest before he did the search. That's what he says. And he says, anytime that we arrest a defendant and we're not going to release them immediately, we have to keep the car. Then when pressed by defense counsel further, he admits that no, actually, he doesn't always keep the car in those cases. And defense counsel says, well, why did you in this case? He says, I don't know. So he's given 3 different reasons for why he's vouchering this car, whatever you take voucher the car to mean. Either he's vouchering it because of the drugs, he's vouchering it because of the false personation arrest and the fact that the defendant is not going to have a desk appearance ticket, or he doesn't know why he's vouchering it. So that's why this inventory search does not meet the criteria. It's not about whether the certain vouchers were filled out or not filled out. It's about the testimony of the person who performed the search and the fact that he didn't perform it wanting to make an inventory to protect property.
What was supposed to happen to the car once they decided they were going to keep control of it?
Your Honor,
didn't they have to do an inventory search?
Your Honor, they don't have to do an inventory search. If they're going to...
Doesn't police procedure call for an inventory search to be done under those circumstances?
Not necessarily, Your Honor. Not in every circumstance, and the fact that he testified different things as to whether he was going to keep the car originally.
Well, where was the car going to go?
Sorry?
Where was the car going to go?
What
was going to happen to the car?
If he had not taken it with him?
Yes.
So there was no testimony. It was parked in a school parking lot. There was no testimony as to whether that was legally parked, not legally parked. But the point is that here, not only did... Oh, okay, I'll finish up on
let you finish that, and then I have a question for you that you can marinate over, and you can answer that on rebuttal, but go on.
Okay, well, I was just going to say, not only did the officer not testify credibly and consistently as to the purpose of the purported inventory search at the precinct, his memo book, as I'll address on rebuttal, clearly indicated that he actually found the cocaine earlier on scene. So even the purported inventory search at the precinct is not really relevant because that's not where he actually found the cocaine.
All right, and then what I want you to marinate on is the evidence showing that the officer followed the NYPD patrol guide in searching the vehicle and created the inventory list. So you can talk about that on rebuttal.
That's generous. Thank you, Your Honor.
All right.
Good afternoon. Mary B. Jumanian for the people. Your Honors, there is no record support for defendant's argument that the search of the car occurred on the scene or was a search for drugs. In regards to the memo book, the officer filled out the memo book here hours later after the search had been conducted and defendant had been charged with drug possession. Even if the defendant was additionally charged with a false personation, the headline charge here would...
So the memo book may create an issue for you, but it's not definitive evidence that he found the cocaine before the inventory search.
Exactly, Your Honor. And it stands to reason that hours later, when this officer is completing the memo book, that he would list the headline charge, which is the drug possession, on the same line as the time of arrest. And
is that what he testified to at the hearing?
He said that that is simply how he takes his notes. That's his note-taking style, and that he completed it hours later.
I mean, does an officer fill out the memo book as he's engaged in the activity, which he will document in the memo book?
No, the officer was not taking contemporaneous notes while he was conducting the search, and there's no requirement that any officer does so. I would also like to add that the hearing court,
Any requirement that it be done within an hour, a day, or something like that? Or can it be done anytime?
I'm not sure if there's an exact time requirement, Your Honor, but this officer testified that he completed it a few hours after. And I would also like to add that the hearing court is amply well positioned here because the judge below watched this officer testifying, including extensive cross-examination on this exact issue, but with the added benefit of having actually seen the memo book, which we don't have here.
How about your friend's comment that that question why the car was even brought in, why the defendant's car was even impounded?
The officer's statement?
The defendant's car.
Um,
Why was it brought to the precinct?
Right. Well, the officer, the car was linked to an iCard, and it was clear that the officer testified that he had reached out to the station house and knew that the defendant was going to be brought back to the station house for questioning, and the car could not have just been left at the school parking lot. And
Is that what he testified to at the hearing?
I believe so. I believe so.
How is the iCard linked to the car?
The defendant's car was depicted on the iCard, including the license plate, and that's how the officer initially recognized the car.
So it was just the car on the iCard, or the defendant also was on the iCard?
I believe the defendant also was
Oh,
on
the car and the defendant.
For sure the car was on it, but I believe the defendant was on it as well, yes. And I would also like to add that the iCard was not related to drugs in any way. It was in relation to a shooting. So there's nothing here to support that the officer suspected that there would be drugs in the car.
With regard to the iCard, I thought the iCard or at least that the officer testified that he wasn't sure if more was contained in the iCard other than a photograph of the defendant.
I'm sorry, I don't think I understand your question, Your Honor.
Well, you just told him that the iCard listed the car and the defendant. And what I'm looking at in the testimony is that the officer said he wasn't sure whether the iCard only had the defendant's photograph.
The car was depicted on
the
iCard, yeah, or there was a wanted flyer and an iCard, I believe.
Thank you.
Okay, Your Honor, let me answer your question first. So what's key here is that any procedure has to be, for an inventory search, has to be followed in good faith by the officer, and it wasn't here. So I'm not here nitpicking about how property invoices were filled out and at what time. I'm talking about whether this procedure was followed in good faith. And this memo book and the fact that this officer contradicted himself on the stand, together with the entire context of this arrest, indicates that he, in fact, created this inventory after the fact to make the cocaine he'd already found admissible. It was not administered in good faith, and it's therefore not an inventory search.
So in the earlier part of your argument, you seem to suggest that it wasn't necessary to do an inventory search at all. It seems to me very likely that if they had impounded the car and not done an inventory search, you certainly would have been very upset about that, right?
No, Your Honor, because the default is that in order to search someone's property, you need a warrant. And if they're going to prove, it's their burden to prove an inventory exception inventory exception to the warrant requirement in order to do a warrantless search. So this is not just a matter of routine that gets ticked as a box regardless of what the actual purpose of the search is. It has to be applied in good faith. And in fact, the default
But you
is
do
no
agree
warrant.
that if the iCard lists that car, that presumably because the car is listed on the iCard, it's going to be impounded. And once it's impounded and also on the iCard, that there should be an inventory search.
No, Your Honor. The iCard, in fact, that's not what the officer testified. His many versions of why he impounded this car, none of them involved the iCard, in fact. He said,
So are you saying that the testimony was that the iCard did not have the car listed on it?
no, Your Honor. The officer didn't testify that the iCard had any. He didn't testify that the iCard was the reason he impounded the car. He didn't make that connection at all, and it doesn't seem like that. He testified that he vouchered the car because of the drugs, or separately contradicting himself, that he vouchered that he just had decided to keep the car and voucher it from the beginning because of the false personation arrest. Or C, he doesn't know why he vouchered the car. Nowhere does he say, I vouchered the car because it was part of a suspect iCard.
Thank you.
Thank you.
Drummond v. Associated Test and Balance. Counsel, before you begin, let me say that I misspoke, and you have 2 minutes for rebuttal, okay? All right.
Thank you, Your Honor.
You're welcome.
Eric Leiter of Morrow Lilling Party for the appellants, Associated Test and Balance, Inc.
I want to be sure that I understand what your point is in the brief. There was evidence in the medical records that the plaintiff was a heavy smoker?
Yes, that's one of the issues.
And that he drank heavily too?
He did.
So there was, the medical records actually reflected that, and those medical records were being admitted into evidence, were they not?
Not with that information.
I'm getting to that, but these were medical records that were actually admitted in evidence.
Yes, with that redacted.
But they were redacted. The references to the fact that the plaintiff smoked and drank were not permitted to come in.
Correct.
And you were having doctors testifying, weren't you?
Yes, we had experts.
And those doctors weren't able to comment about the fact that that the plaintiff smoked or drank because the evidence of that had been redacted, and you had been instructed based upon the in limine motion of the plaintiff that that material was going to be excluded.
Correct. The jury neither saw the information nor were we permitted to have any witness testify about it.
And also the life expectancy table undoubtedly was admitted and was given to the jury too.
It was.
But the fact that the plaintiff smoked and drank was not something that you could make reference to, even though a jury is typically told that the life expectancy figure I have given you is not binding upon you, but may be considered by you together with your own experience and the evidence you have heard concerning the condition of plaintiff's health, his or her habits, even though that's part of the standard charge which is given to every jury on this type of a situation.
Correct, and in this case...
That's what's occurred, that is what occurred here.
Correct, and they did not know his habits because it was precluded. The fact that...
Did you offer any expert testimony regarding his habits and how that might have reflected on his health?
We had 2 experts that were going to be called that were, three doctors, in addition to...
So my question is about an expert relating to his habits, namely the smoking and drinking, and what that would do with regard to his health.
There wasn't a specific expert designated to speak exclusively as to that, but the doctors in the reports that were exchanged noted that they had reviewed all of his medical records, with those medical records including the notations about his smoking and his drinking, that they would be addressing all of the claims that he was making. The duration of any claim is also inherently a part of every claim he makes, and I would submit that even without an expert testifying, as the court even noted, notwithstanding
You cite to the Doe case, which demonstrates that the fact of a person, of any person knowing that smoking has an impact on someone's health is a very well-known fact. It's not something which you need expert testimony for someone to know.
Yes, the fact that smoking is bad for your health is something we don't think is beyond the ken of the average juror.
But besides that, you were having doctors coming in to testify who certainly would have the expertise to testify what the effect of smoking would be on someone's health and its possible effects on their life expectancy.
They certainly could, and explain why it has that adverse impact on their health.
And did any of the doctors' reports specifically say that they had drawn any conclusions about the impact of the plaintiff's drinking and smoking on his life expectancy?
The medical records themselves from the VA hospital...
I'm talking about the experts.
I don't believe the experts themselves reference that. I think it's only in the plaintiff's own records when they talk about when he's counseled for smoking cessation.
Is that something of such common knowledge that you wouldn't expect that a doctor's going to tell you smoking is hazardous to your health?
Yes, and certainly we didn't think we would need to put it in expert disclosure that the doctor, by his training, is going to be able to say that or to form that conclusion.
Isn't there a difference between saying that smoking isn't good for your health and to say that the amount of the plaintiff smoking would decrease his life expectancy by X?
I think both are commonly understood, that smoking is not only poor for your health while you're alive, but tends to shorten your life.
But we don't know. I mean, as to any individual, I'm not sure that anybody with that expert testimony would know how much it would decrease someone else's life, right?
Right, like how would we get around having just an arbitrary number of years decreased by, right?
So I believe
because there are some people who smoke and drink and live long. Some people who smoke and drink don't live long.
Correct. And so where the PJI charge provides that the jury is to take into account things like a person's habits, it's not that there's a requirement. If, for example, the person is a skydiver and they do that routinely, the jury can then take into account this person engages in risky activities.
But the life expectancy tables that are given to the jury are themselves really, if you will, arbitrary. It's not necessarily something which scientifically applies to the plaintiff that's on trial. This is a general statistical fact which our judicial system has come to rely upon, and the fact that smoking is hazardous to your health and to your life expectancy is of similar nature.
We would agree.
I have another issue I want to discuss with you, because you say, the myelopathy, right?
Yes.
That the jury improperly considered that because, the court precluded that. But isn't it fair to say that, the BP and the medical records, they talked about the cord compression, and isn't it like semantics? We're saying myelopathy, cord compression, that's kind of like one and the same.
It's not, and that's a very important distinction that the plaintiff has always tried to blur. If you look at page 45 of the appendix with their bill of particulars and what it is exactly that they alleged, is totally different from what they sought to prove at trial. At trial, they claimed that the plaintiff has gliosis that caused cord compression and all of his symptoms.
Okay.
Now, when we look at the BP, the only reference to any kind of compression of the spinal cord is an allegation that the plaintiff has cervical disc displacement impinging on the nerve roots and compressing on the spinal cord/column. So glial cells have nothing to do with cervical discs. They are not one and the same. They're not even close. They're completely different. The disc doesn't enter the spinal cord. It surrounds the area. The claim, and we have such junk medicine from Dr. Lubliner and Dr. Guy, so the suggestion that the spine...
medicine?
I would say. Certainly a claim that a spine passes through the neural foramina when it does not would certainly be junk medicine.
Well,
Dr. Guy's testimony...
let me, we're over time, but, you said something that certainly triggered in my mind, because it seems to me that all of the experts agreed on the cord compression and that it could be induced by trauma, but the one thing they did not agree on was causation, because all of the, the medical experts, they, presented with, how would I say, the necessary qualifications to testify. So this junk science, I don't know if I'm buying that, but certainly the experts agreed on everything. His injuries, your expert conceded that it could be, induced by trauma, and that some of the complaints that the plaintiff had post didn't exist previously. Certain things in the medical records at the VA, they were post-accident. But we're going to hear from your friend here.
Thank you, Your Honor.
Okay.
Good afternoon again, Your Honors. Brian Isaac. I represent the plaintiff respondent.
Counsel, let's go to the issue with the smoking and the habits and it being within the ordinary kin of a juror. In conjunction to what my learned colleague here just mentioned, that these life expectancy tables are speculative anyway, but we use them, why is it that you need an expert to say that smoking and drinking will diminish your life expectancy?
The answer is very simple. The answer is because something is generically true doesn't mean it's specifically true with respect to a lawsuit. Now, I'm not saying that they couldn't have made that claim. They could have. It was a legitimate claim. I've been involved in some cases where the cases actually
I
got...
struggle to understand. I mean, you know, you might say there are severe limitations on what the defense could do with the records if they don't have an expert. Putting that aside, but to say we're going to tell the jury, as PJI Charge 2:2-81 says, you're to consider habit, and then we redact from the medical records the fact that this person is a heavy smoker. I don't know what you can do with that evidence. You may have in limiting applications which should be granted, what the defense can do with it, but that you don't even tell the jury, you make it seem like the plaintiff is something different than what he actually is by redacting this smoking evidence, and then you tell the jury, you can consider habit.
Well, I see you don't like it, don't like that particular scenario, Judge Friedman, but let me offer you a reason why it makes sense, okay? And the reason is really very simple. Litigants are the masters of their own course. They can make claims, they cannot make claims. I'll give you an example. Let's say that the medical record said heavy eater, ate at McDonald's 15 times a day. That's not good for you. Not exercising isn't good for you, but you need to tie it so the jury has some idea. Just to say that things are generically not good for you doesn't mean it's fair game, and you do need an expert when you're talking about life expectancy tables, precisely because they're so imprecise. How's a jury going to make that determination?
Well, there were doctors coming in to testify.
I'm sorry, I didn't mean to cut you off, but they were testifying as to matters not dealing with smoking. That was the argument. The argument wasn't that the claim was never one that was cognizable. It was one that they didn't even plead.
You have to specify.
Oh, so they didn't plead that.
Talking about smoking.
They didn't plead that.
There's no expert. There was no expert disclosure saying we're going to come in and talk about the plaintiff's tobacco use. We're going to talk about his habits.
The medical records reflect that he's a heavy smoker. Do they have to make a disclosure that our medical experts may come to the point of saying something about his smoking?
Absolutely.
Well, because you have to tie it into how does that diminish specifically in his case his life expectancy,
Correct.
right?
And I just, because you caught me a little off guard with the question, but I did read the medical records. I obviously didn't write this, but I read every medical record. I want to read something to you. In the record, 981, bottom. It says ROS, general, no constitutional symptoms, cardiac, no chest pain, no dyspnea. You ready? Quote, word for word. Has good exercise program, walks for miles, no problem. So, yeah, he might have drank.
So that came in.
That was it. Nobody made a motion
That
to
was
redact it.
before the jury, but the fact that he's a heavy smoker wasn't.
I'm sure that no juror looked at this. That's my point. My only point
It's
is...
in evidence.
It is, but my
we
only
can't
point-
operate under that assumption.
No, I'm not, I didn't mean it that way.
Even if you're right, we can't operate under that assumption.
That's a fair enough point. All I'm saying is that if you look at this, all I'm saying is the fact that he's a heavy smoker or the fact that he had tobacco doesn't mean that his life expectancy is diminished, and it's not something that jurors can...
Oh, you're saying because he was able to do that?
I'm saying that you can make the claim, but they didn't make it, and there's evidence here to show that this is a fit person. So that it just goes to my point, not that the claim's never cognizable, but you have to plead it. If you don't plead it, then it doesn't come in, and that's especially telling here when my good friend is saying, wait a second, you stipulated to withdraw all the claims that were here, so you don't even have a case because you didn't use the word myelopathy. And I'm not going to go over my time, but I did want to point something out. 45, we specifically say compressing on the spinal cord column, and then it says spinal cord edema. I looked through the record, 473 lines 19 to 21. This was the original motion. Now, I think I read it right, even though it didn't come out this way, and this is what the court said. And defendant's motion in limine to preclude plaintiff from seeking past medical special damages alleged myelopathy trial is granted. That's clearly not true, but that was the original holding. Then I'd like you to look at 619, starting on line 18 through 24. This is Mr. Harris. He is partially disabled secondary to his cervical myelopathy with imbalance and subjective complaints of paresthesia in the upper and lower extremities, as well as spasticity in the lower extremities. And he's quoting from Dr. Bendo's expert report. He says, based on that, Your Honor, I don't see how we avoid the term throughout the course of the trial, and that's all I want to say. Then the defense lawyer. This is 620, lines 16 to 19. Listen to this. To the extent that plaintiff now indicates he may intend to circumvent this court's ruling by having the doctor testify to myelopathy without saying the word myelopathy, it's clear that the expert is not permitted to testify that plaintiff has symptoms from cord compression because that would be myelopathy. We read cord compression. The fact that he has cord compression. And I would point out to the court, I'm sorry, can I just have 15 seconds?
Yes, you can.
Thank you. If you look at the MRI report, I'm going to give you the pages. 60 and 57, CAT scan and MRI. This is what it says. Cord compression and likely cord edema / gliosis. It doesn't say or. It says the same thing. Gliosis is nothing more than a proliferation of cells, and we specifically claim cervical edema. So there was nothing that was wrong here with respect to what we did, and in fact, we ended up getting a verdict despite a ruling that was adverse to our interests. Thanks.
Thank you.
Thank you, Your Honors. I want to note that where there was agreement, the agreement is not helpful to the plaintiff because the agreement that the doctors have between them is where Lubliner acknowledges that what this plaintiff had, the particular type of myelopathy he had, is cervical spondylitic myelopathy, and that's on page 669 of the record. And spondylitic myelopathy is by definition degenerative. There are other types of myelopathy. There are myelopathies that can be traumatic, but the myelopathy that this plaintiff had, that every doctor agreed this plaintiff had, is specifically a degenerative condition. And so the feigned issue was when Dr. Lubliner tried to claim, and when Dr. Guy claims that osis means inflammation when it doesn't, that's itis, when they tried to claim that spondylitic myelopathy is a traumatic injury. It is by definition, and we cited cases that have taken judicial notice of the fact that it's a degenerative condition. We cited a medical journal noting over 1,500 journal articles rejecting what Dr. Lubliner claimed. That's why I referred to it before as junk medicine. It's why I stand by that representation. That is what the dispute was. And the ruling from the judge, which on page 994 clarifies what's been said here. The question is not whether or not this plaintiff had a degenerative myelopathy. He did. The question was whether they could claim that he's entitled to recover for having a degenerative myelopathy. And the court said, it's on A994, Judge Samaj specifically said, quote, whether or not plaintiff has myelopathy is not the issue. Myelopathy as a result of this incident is the issue. And plaintiff was precluded from claiming he has myelopathy as a result of this incident or as a result of gliosis because he did not plead gliosis, he did not plead myelopathy, he did not plead myelopathy as a result of gliosis. The court ruled that it was precluded. The plaintiff rejected the court's ruling, and on page 2 of its brief continues to argue the judge shouldn't have ruled against him.
Thank you.
Thank you, Your Honors.
If I may?
I'll allow it.
I just want to switch issues here. The lumbar spine, which which plaintiff have withdrawn from their claims, but that was included in the calculation for future medicals and future pain and suffering.
Yes, Your Honor. $1,782,847 of the roughly $2.2 million life care plan was for the treatment of the lumbar spine, notwithstanding that the lumbar spine injury claims were all completely withdrawn. So the life care planner Dwyer testified to those costs, having testified before the withdrawal of them, and then Dr. Guy acknowledged he had not updated anything. So the jurors heard that number. We asked that a curative instruction be given to make clear that they can't make an award for it, when Dr. Guy especially then added, it's been withdrawn, but he really has it from this accident, which is prejudicial. and then they awarded more than they ever could have awarded just on the basis of cervical spine injury claims. So even if you weren't precluded from claiming the myelopathy and they wanted to award them the full amount for the treatment of that, that still wouldn't reach the number they awarded.
Thank you.
Thank you, Your Honors.
Jeffries LLC v. Mountain State Energy Holdings.
Good afternoon, Your Honors. Eugene Sokoloff for the appellants Mountain State and Trilogy. The tortious interference claims here.
Get closer to
The tortious interference claims here each fail for the same reason. They each hinge on a breach of the party's contract. The fraudulent inducement claims fail, as the trial court found, for the failure to plead scienter, but they fail for other reasons as well, including the waiver that is on the face of the complaint and the plaintiff's inability to plead compensable harm. If I could start with tortious interference and the non-recourse provision here, that's the claim as it's asserted against Trilogy, which was not a party to the agreement between Mountain State and Jeffries. The sophisticated parties here agreed to the broadest conceivable non-recourse provision I think you can see. Among other things, it covers, this is at Record 76, any cause of action, including torts, that is related in any manner to this agreement or based on or by reason of this agreement or its performance or its breach. The court cannot decide the tortious interference claim here without deciding whether there was a breach of the contract, and here's why. What was the tortious interference? Take a look at paragraphs 67 to 68 of the complaint, that's at Record 59. Refusing to allow the double line trade. It says, quote, by refusing to authorize the sale of the shares in Mountain States to Jeffries, end quote, they tortiously interfered in the agreements with the third parties.
Can you
What-
just move the mic closer?
Sorry. What was the supposed breach here? If you take a look at Record 56 to 57, paragraphs 45 to 47, well, it's the exact same thing, refusing to allow these trades. There's a perfect overlap there, and I don't think that if this text doesn't cover a claim that has to drive through the breach claim, it's hard to see how any non-recourse provision would be enforceable. If I can turn to the duplicativeness of the tortious interference claim that's asserted against Mountain State, it fails for exactly the same reason, right? This court has said in cases like JHH Pictures that a tortious interference claim that is grounded in the same conduct that is alleged to be a breach of a contract should be dismissed as duplicative of the contract-based claims. And that's exactly what we have here. The allegations expressly tie the two together. Now, the trial court thought that the key question here was whether the agreements that were interfered with were related to the agreement between the parties. But that's not the question under the plain terms of the non-recourse provision. The question is whether the claims are related to the parties' contract, and here they clearly are. I want to briefly address the waiver argument my friend has made here. I think it's clear under this court's cases, Chateau d'If and a number of others at the motion to dismiss stage like DeLuca and Newport East, that when you have a pure question of law that is dispositive and evident on the face of the record, it's one this court should reach. Why kick the can down the road and kick the claim later? If I could turn to the fraudulent inducement question. Here, the trial court was absolutely right. The complaint simply fails to plead scienter. The definition of evaluation materials under this agreement was essentially, it's a very long clause, but essentially at Record 69, evaluation materials are anything that Jeffries gets from Mountain State, except anything that Jeffries already had, either because it was in the public domain or because it got it from an unaffiliated third party, somebody not related to Mountain State. Well, there is nothing in the complaint that alleges or creates any factual basis to think Mountain State could have known what other unaffiliated parties had already furnished to Jeffries. And Jeffries says, well, you knew what confidential information you had given to third parties, maybe, but we had no way of knowing, and the complaint pleads no reason to think we could have known what third parties gave to Jeffries.
Can you just address, the argument raised, by, your adversary that, the non-recourse provision, it does not apply because of the, exception, because the complaint alleges that Trilogy did in fact, engage in tortious behavior.
Sure. So I think this is something that is best explained by this court's decisions following. So this is in Devash that we cite in our brief and Meridian. Both are motion to dismiss stage cases, and both hold that it is on the plaintiff to plead that the defendant acted in a manner that is, quote, unrelated to any legitimate economic self-interest. And here the complaint pleads the opposite. The complaint alleges, this is at paragraph 37, that Trilogy didn't want this deal to go through, quote, because they had spent a great deal of time working on Mountain States. They wanted to protect their
They wanted money. They wanted money, and that's a legitimate economic consideration.
Exactly. And so there's two things. One, they wanted money because in their view, this was not an eligible transaction that Jeffries had a right to make under the contract, right? Jeffries, if I may, Jeffries is under a standstill. So the default under this contract, they can't buy anything unless it fits the carve-out. And the position that Mountain State and Trilogy took was, this doesn't fit the carve-out. Now, we can waive that and make an exception, but we want consideration for that. And there's nothing wrong with demanding consideration for waiving a contractual provision.
Let me ask you this, what about that statement, that Trilogy's executive made? We don't want Hudson Bay or anyone else into our blank, I'm not going to use that word, you know what it is, party. So what about that? Can you address that? Because, they're saying possibly that could be an expression of economic self-interest.
Oh, I think it's exactly an expression of economic self-interest, right? This obviously he expressed himself with some warmth, but the point is he did that.
That's a good way to put it.
And look, this is not me just telling you. This is the complaint alleges it. The complaint alleges he said we don't want anybody on our party because we spent a lot of time on this investment, and there's nothing wrong with that.
Thank you so
No
much.
further questions. Thank you.
Good afternoon. May it please the court. I'm Scott Balber for Respondent Jeffries LLC. Let me start with the tortious interference claim that was, as to which the trial court properly denied the motion to dismiss.
So, counsel, you agree that you would have to plead something other than your economic interest, right? That this was done for economic interest.
Well, I agree with that. That's right, Your Honor. And I believe that my friend is conflating two categories of contracts which have separate purposes. And as a result,
Well, what in the complaint have you alleged that establish that this was done for something other than economic interest?
Because the purpose, the express purpose, as alleged in the complaint, was to prevent my client from entering into an agreement with a third party. And the economic interest, they may have also had an economic interest, but they were intending to assert their will in a manner to keep control as opposed to allowing third parties to become investors.
But they had a right to do that, didn't they?
I'm sorry, Your Honor?
They had a right to do that, didn't they? They were in control. Trilogy had a major interest. They didn't have to surrender that, did they?
They absolutely did not have a right to do that, Your Honor. That is not the case.
You were engaging in what they finally determined was not a related investment activity.
That's what they've claimed, exactly. They claimed that the two trades which we tried to consummate were not related transactions under the purview of the confidentiality agreement. But what's important here is we had a right to enter into any transactions, period, without regard to the confidentiality agreement. So just to take a step back.
But you agreed to a standstill, didn't you?
We did agree to a standstill, and what remains at issue in the case is what the scope of that standstill was.
And then you wanted to sell, you wanted to get SciX and you wanted to get Double Link in. So you entered into another agreement.
Well,
and one of those they allowed you to go forward with, and the other one they say, look, this is not all one agreement. These are two different entities.
That's exactly right. And what happened was we have the right under the confidentiality agreement to enter into a series of related transactions. We entered into a transaction with SEIX on day one, and an almost identical transaction with Double Line for the express purpose conveyed to defendants of selling both those tranches of shares to a third party, Hudson Bay. So yes, we allege that those were all part of a series of related transactions as a set.
Did they not have a right to take the position that these are not related transactions? A transaction with CX is not a transaction with Double Link.
They absolutely had the right to take that position, and that was a breach of the contract, and separately precluded us from entering into these trades with third parties, which
Well, they allowed you to enter into the transaction with CX.
They did allow that. That's correct, Judge. And then there was a second component of the series of related transactions, which was a contemplated purchase from Double Line.
But they didn't see it that way.
Well, that's one of the reasons why we're here. That's exactly right.
Right, so when Kiefer of Mountain State said to unravel one of the deals, and then you consummated the deal with SEIX, then you still later on, about 20 days later, went ahead and talked to Trilogy and talked about Double Line. So that's a separate deal that wasn't part of the your related deal.
See, we flatly disagree with that, Your Honor, and let me explain why. Both the Double Line trade, the SEIX trade was consummated. I believe 2 days later, we sought to consummate the Double Line trade. And before either of these trades were entered into, my client conveyed to Mountain State that both those tranches of securities, the purchase from SEIX.
Originally, they're going to go along with it, but then they come to realize these are two different trades, and they don't have to go along with two different trades.
Well, they're not two different trades. They're part of it. The
two
contract says
two different deals, two different transactions.
The contract.
CX is not doubling.
The contract that they signed allows us to enter into a series of related transactions.
Why isn't that an allegation of breach of contract?
Well, we have that, and that is nonetheless viable and pending in the Supreme Court. They moved to dismiss that component of the complaint as well. That motion was denied. That's going forward.
So why isn't the claim you're making now not duplicative of the breach of contract claim?
Well, because, thank you, Your Honor, for getting to the question I wanted to answer, because Trilogy, against whom we assert the tortious interference claim, is not a party to the contract.
The no recourse, right, provision precludes you from suing Trilogy, no?
No, because again,
for tortious interference.
The answer is right. The answer is it does not, because it's not the confidentiality agreement that gives us the right to enter into these trades. We had the right to enter into these trades under the LLC agreement.
And they have the right to say no.
Well, and that we say is a breach of contract, and
they're not part of your contract, as you said.
Trilogy is not a part of that contract.
They're not party to the confidentiality agreement, exactly.
So
what they did was, and I'm not going to quote the
Doesn't Trilogy have a right to say, if we're to go along with this, we want to be paid? This is a very valuable interest which is being purchased, and if you're to be allowed to get into the party, you have to pay for it.
Right, but that was there's no contract between the parties that are before this court that gave Trilogy a right to demand an extortion payment to allow the trade to go through.
Is that extortion or just the money that they requested for you to become a part of the party?
But they didn't have a right to do that because they weren't the ones who were allowing or selling or authorizing the shares. Trilogy was a shareholder, and I'm sorry, I realize I'm over it. Let me just.
But I'm allowing this.
Thank you, Your Honor. Trilogy was a shareholder. Trilogy was not a party to the agreement that enabled us to sell the shares, to purchase the shares, or sell the shares. So what right do they have, I ask rhetorically, to demand an extortion payment when they didn't have a right to authorize the transaction, prevent the transaction, or anything else? They are a third party to the agreement that enabled us to enter into the trade in the first place.
And why did you go to Trilogy?
I'm sorry, Your Honor?
And why did you go to Trilogy?
Well, we didn't go to Trilogy. We went to Mountain State. Trilogy, as the shareholder,
I think you contacted Trilogy directly and spoke to Mr. Rosenstein.
Well, to add complexity to this, there is a ROFO right, a right of first offer, that is contemplated by these agreements. Again, not the confidentiality agreement and not the trading agreements, but rather the LLC agreement that governs the relationship between all the parties.
That's why I don't understand it. You say that they have a right. There was a right of first refusal. You had to get past that right of first refusal.
But they didn't exercise that right of first refusal. That's not, see, that's exactly an important point, Your Honor. They didn't allow the trade to be, so the right of first refusal had already been waived. They then changed their story and decided they're going to ask for a payment when they had already waived their ROFO right under the LLC agreement. That's exactly it. And that's why it becomes a Turkish...
But you had agreed to a standstill, hadn't you?
Not with Trilogy. And the standstill, and I don't mean to repeat myself, and I've said this a few times, allowed us to enter into...
You weren't supposed to be buying it all at that point during the standstill unless you got permission to buy.
That's not true. We had an unfettered right to enter into a series of related transactions.
That's the subsequent agreement, but not under the standstill agreement.
No, that's the same agreement. Same agreement we're talking about, Your Honor.
Thank you, counsel.
Confidentiality agreement?
Confidentiality agreement, exactly.
We're now going to
Thank you,
hear
Your Honor.
from
Thank
the
you
other
for the
side.
extra time.
Just very briefly, I think everything that you've just heard from my friend just reinforces why this falls within the non-recourse provision with respect to Trilogy. And I don't even think that I hear Jeffrey's arguing anymore that there isn't duplication with the contract claim with respect to Mountain State.
Who controlled Mountain State?
Who controlled Mountain State?
Yeah, who had control of Mountain State?
That is not in the record, and I personally don't know.
It's not Trilogy.
Not as far as I know, no. And that's not alleged in the complaint. What is alleged in the complaint is that Trilogy had a role in deciding whether this was an eligible transaction. And let's say you believe that. That goes to a breach of contract, because the question then becomes, well, who had the right to make the decision? Was the decision a good one? Were they entitled to make this trade, or had they in fact agreed under a standstill that they would not make any trades that weren't eligible, with Mountain State with discretion to determine what was eligible? We can litigate that on the breach of contract claims that are going forward in the trial court.
This non-recourse seems like it was almost drawn in order to protect Trilogy from being subjected to suit. I mean, these protections against third parties had to have been for the benefit, it would seem, of Trilogy.
Of course. I mean, obviously, they work both directions, right? We could not be here suing somebody, associated with Jeffries that was trying to do a similar thing. This is a two-way street. It was an express and extraordinarily comprehensive and detailed limitation of liability under which the parties agreed, look, if something happens related to this deal, we'll sue each other, but you can't sue anyone else. And if there's ever been language that encompasses a dispute like this one, I think it's what you'll find in the non-recourse provision. If there are no other...
Ben said that Trilogy isn't part of that agreement.
Well, that's the whole point. If it was part of the agreement, it wouldn't be subject to the non-recourse provision. Right. So, I mean, that's why we win on that point, is that we're not parties to the agreement, but we are definitely covered by the non-recourse provision. It covers everybody. And we're covered because the claims...
He said he was moving under the litigation agreement and not the confidentiality agreement.
So I think that you're referring to the carve-out, which is the provision that would allow them to make related transactions. That is an amendment to the confidentiality agreement. It's the same thing, and that amendment expressly preserves the non-recourse.
It's the last of the agreements.
It's the last, right, and it's simply additive. The only thing it changes is it adds that provision that permits, under certain circumstances, them to make related transactions. It does not get rid of the non-recourse provision or limit it in any way. It's subject to exactly the same provision.
Because absent that, they would have been bound by the standstill and they couldn't.
That's exactly right. And they sought that amendment because they wanted to buy this equity. Well, they got to buy some of it. They made these two trades that were related. They didn't get to buy the rest of it. They're upset about that, and there is a breach of contract claim pending in the trial court that will address exactly whether they're entitled to relief, but what they're not entitled to do is sue a third party given this non-recourse provision.
Thank you very much.
Thank you, Your Honor.
People v. Phoenix Goings.
May it please the court, Lawrence LeBrew on behalf of the appellant, Mr. Phoenix Goings. We're asking the court to reverse this conviction on the grounds that Mr. Goins was denied due process of law and he was denied his right to confront all of the witness against him. That due process argument has two components, a substantive due process component and a procedural due process component.
Are you talking about the analyst?
For due process, I'm talking about the DNA sample. For confrontation clause, I'm talking about the analyst and the DNA report. For the DNA sample, our position is that sample was illegally obtained. It was some type of plea agreement in another case where the prosecution agreed to dismiss the case that is the subject of the DNA sample and the subject of this appeal pursuant to 16050 and 16060.
What was your client's fingerprint in the other case?
I didn't hear you, Your Honor.
Sorry. Was your client fingerprinted in that previous case?
That previous case, yes. That previous case went through to the indictment stage.
Okay,
after
and
he
so
was-
didn't those fingerprints go through the CODIS program?
They went through, once he came into the system, everything went through the regular process.
Okay, so his DNA wasn't CODIS.
Well, here's the issue. Once that case, well, regardless of what happened with that case, once that case was dismissed and sealed under the criminal procedure law, Mr. Goins was returned to the position that he was in before that case even happened. Okay, so theoretically, under the law, there's no DNA sample.
Let's just go back. So the buccal swab, right? It wasn't subject to DNA testing, right? Because it was entered into a database and it matched the defendant's profile from the 2010 case, right?
Right. The 2010 case, they got a proper procedure in front of Judge Whitner, and they properly obtained a buccal swab. That swab was not tested, but apparently it was entered into, I'm not privy to the procedures of the state, it was entered into some database.
Oh, but nothing was taken. Nothing was taken.
What do you mean nothing was taken?
Just what I said. You
Well,
know, there
something
was a swab that was entered into the database and it matched.
Well, here's the problem. There's a missing link there, okay? There was a swab. It was entered into the database. The case that formed the base of that swab was dismissed and sealed. After the case was dismissed.
But it wasn't deleted from the CODIS database.
Correct. It was not deleted from the CODIS
So
database.
what's wrong when they take this DNA and there's a hit in the database? What have the people done wrong?
Well, when the people take this buccal swab, they're taking the buccal swab from the sealed case. So you can't take the buccal swab from the sealed case because that case has been dismissed and sealed. So that buccal swab under...
They got DNA from this case, didn't they?
No, they did not. They got the buccal swab from the 2010 dismissed case, okay?
I'd like to move to another area. You know, let's
Go
talk
ahead.
about the confrontation clause, you know, Garrett, right? Because she testified that she conducted her own analysis. She did an independent review of all of the testing and the analysis that were done, and she came up with her own conclusion. So what's wrong with that?
There was no independent analysis. The testimony indicates that a prior analyst actually tested the DNA.
Right.
That analyst tested the DNA and issued a report. An accusatory instrument was drafted off of that analysis report, and the defendant was indicted off of that analysis report. Another analyst came in and looked at the paperwork generated from the testing process. She did not conduct any...
She looked at the raw data, right?
No, she
said that in her testimony.
Well, raw data, you can call it raw data, you can call it right data, you can whatever data it is, there's a process with DNA testing. So there's raw data after the testing, there's raw data before the testing, and there's the testing. The critical issue for the court as far as the confrontation clause is the person that did the testing, the person that signed the report, are they available? That person is not available.
Is that what our case law says? That
That's
that,
exactly.
that an analyst who looks at the raw data makes their own conclusions based on that raw data cannot testify without it being an affront to the confrontation clause?
That's what the United States Supreme Court said after the Court of Appeals ruled on the
You'll tell me
issue.
what case the United States Supreme Court said that in. And
That's in our brief. The main case cited in our brief, Arizona. It's the main case cited in our brief.
I know that you also acknowledge, People v. John. You acknowledge that holding, but you say that in spite of that holding, there should be a new test with new samples. But on rebuttal, you can tell me if there's a case to support that claim. We'll hear from the people now.
Smith versus Arizona.
Okay, but we'll hear from the people now.
I'll address that.
Okay.
Good afternoon, Stephen Kress on behalf of the people.
Let's see if we can clarify this DNA issue. You get DNA evidence out of this case from a cell phone, from a hat, and from a vest, right?
That's correct.
And you process that, and then you compare it with what's in CODIS, right?
That's right. They were
CODIS
able
has
to-
this buccal swab, and it comes up with a hit, and you know it's the defendant.
That's correct, yes. So DNA was extracted from the evidence in this case. A profile was developed.
There's no question that the people had a right to have access to the results of the buccal swab, which is in CODIS.
No, that's right. I think the fact that the case where the buccal swab was taken was ultimately sealed, that doesn't mean that your DNA record is expunged from the database. No, it was in the database. That was what generated the hit, and then there was an analyst who did a confirmatory comparison to confirm that it was the defendant's
Counsel, let's
DNA.
talk about the Smith versus Arizona that your adversary just mentioned. In that case, the analyst there didn't do any analysis of raw data, but instead just reviewed and repeated the conclusions of the original analyst, right?
That's right.
And distinguish that from what happened in this case.
Right. So that's exactly right. In Smith, you had the testifying witness who was really incorporating the non-testifying analyst's opinions as the basis of his own. And here, Ms. Garrett was expressly asked, "You are not adopting criminalist Hoffman's opinions." This is page 732. And she says, no. She says that she looked at the raw data that was generated from the first 3 phases of the DNA testing, which the Court of Appeals has said is non-testimonial. And then she did the same thing that the original analyst did. She looked at this data, she analyzed it, you have to interpret it, review it, and she reached her own conclusions as to what it found, and in terms of developing the original profile, and then that profile matching the defendant's.
And the Smith case doesn't say that the analyst who does the actual testing, right, they're permitted to look at raw or right data, whichever one you want to call it, and make an assessment.
That's correct. No, Smith was simply saying you can't have the testifying witness be a mouthpiece for the opinions of the non-testifying analyst, and that is not what we have here at all.
And that's in line with our case law in this department, right?
That's correct, yes, and from the Court of Appeals as well.
Counsel, your friend seemed to be suggesting that when his client's case was sealed, that it was his belief or understanding that any DNA recovered during that case would be expunged or not part of the system. Is there any representation like that made to defendants when their case is sealed, that any DNA results are expunged or?
No, there are provisions in the executive law that deal with expungement, and they deal usually with cases that have been, if you're acquitted after trial or if your case is dismissed for a substantive reason, then you can apply for expungement of your DNA record, but that didn't happen in this case.
And prior to that case being dismissed, the DNA was collected pursuant to a lawful court order, right?
That's correct, yes, that is correct. And I just want to make one last point perfectly clear. At no point did anyone from the DA's office or OCME take the 2011 buccal swab, like the actual physical swab, and then use it for testing in this case. Like that just didn't happen. And then, unless there are any other questions for the court, we'd ask that the judgment be affirmed. Thank you.
Thank you.
In regards to the court's question about People versus Johns and the later Court of Appeals issue that addressed confrontation issues, People versus Jordan, those cases were pretty much overruled by Smith versus Arizona and People versus Jordan.
Smith versus Arizona, as we've just all heard, had to do with an analyst that basically parroted the report of another analyst versus making their own assessment of raw data information. So Smith is not on point with the argument that you're making, which you're saying that the analyst who testifies has to be the same analyst that does the testing, the actual testing.
Respectfully to the court, we're making 2 points here. First, regardless of what you got in the new case, when the case was dismissed and sealed, the old case, 160-50 and 160-60, the defendant was returned in the position that he was before. Second, with regard to the issue that the court brings up about there was independent testing is not reviewing paperwork.
I never said the words independent testing.
Well, independent evaluation. Independent evaluation, okay, and we recognize that the court is saying independent evaluation. Independent evaluation does not meet the constitutional standard for the confrontation clause when that individual evaluation is based on testing or of another individual that's not present in the court. If individual evaluation is the standard for constitutional confrontation, then in effect, the actual physical process that a criminologist goes through for the DNA testing is essentially meaningless for confrontation purposes, because you can have a clerk or anyone doing the testing, and after the actual testing is done, okay, where somebody is present and conducts the testing, then you can just have somebody come in and say, I looked at the raw data, I looked at the statistical analysis, and it looks right, without getting to the underlying issue here, which involves a property
I know I
entitlement.
referred to People v. John, and I'm just going to read just a snippet of it, a portion. The testifying analysis must have either participated in or directly supervised this final step that generates the DNA profile, or must conduct an independent analysis of the data used to do so in a manner that enables replication of the determinations made at that stage in order to verify the profile. Didn't Garrett do the latter?
No, and we submit that that interpretation of the law no longer rules based on the federal rule regarding the constitutional standard, respectfully to the court.
All right, we have your argument. Thank you so much. Seaman v. Pebble Corp.
Good afternoon.
Just wait till he comes up.
I'm sorry.
It's okay. Let me just say before you start, I've recalculated the time. Each one of you have 4 minutes, and you have 1 minute for rebuttal, okay?
Thank you, Judge.
You may begin now.
Okay, good afternoon. May it please the court. My name is Mark Statmauer on behalf of the appellants here. The question here is whether if there is any private legal redress for the customers of a chain.
Counsel, if we were not to find that there's a private right of action, you also argued both below and to us that your complaint stated a cause of action for breach of contract. Are you still
correct.
asserting that claim?
Yes, Judge.
So which paragraphs of your complaint state a cause of action for breach of contract?
It's not in there specifically. I made a mistake. It's on page 50, I believe it's 56 of the record. We're asking for a refund, which I would argue sounds in breach of contract. I should have moved to amend the complaint below. I didn't. But I would ask.
So you're not claiming that at this point that your complaint states a cause of action for breach of contract?
It doesn't say it specifically, Judge.
Okay. And are you claiming that your complaint states a cause of action for unjust enrichment?
Same answer. We've asked for a refund, but those words do not appear in the complaint.
And you're not claiming that the statements in them constitute a claim in any other way?
Well, this is a pre-answer motion to dismiss. We're entitled to every favorable inference, and whether a claim for unjust enrichment fairly exists in the facts, I believe it does. And
Can you tell me where it appears?
well, yeah, Judge. In this case, the plaintiffs overpaid, were overcharged for their meals. And in that situation, where the defendant refused to provide a refund, refused to make...
Contract formation.
When you buy something in a store, that's a contract. There's a price, and they're charged a price, and they're paid a certain amount of money, and when there's a refusal to give change, that's a breach of contract, and that's an unjust enrichment. That's the claim.
This statute is enforced by the Department of Consumer Affairs, right? Or Consumer Affairs Administration.
This statute has a provision for a fine to be levied by the Department of Consumer Affairs. Correct.
Did you approach the Department of Consumer Affairs and ask, why aren't you doing anything about this condition?
No, the Department of Consumer Affairs does not have the right to aggregate claims. It does not represent a class.
Yeah, but the Department of Consumer Affairs, someone could put in a complaint to the Department of Consumer Affairs, and then they would go and fine the entity doing it and perhaps bring the practice to an end.
It could, but that's a $750 fine under the rules. And that is not what we're doing here. What we're doing here is we're asking for a refund, which can only be done in the context of a class action, because we're talking about very small amounts of money on individual claims.
You know what? I'm going to let you finish that sentence, so please finish the sentence.
I did. When you're asking for refunds for small amounts of money on each particular claim, that can only be done in the context of a class action.
Now, so this cashless ban statute expressly provides for public enforcement through imposing civil penalties, right?
Yes, but it's not exclusive.
But it does say civil penalties.
Yes.
And it's silent with respect to private enforcement.
That's correct.
And I know you said, my colleague talked about breach of contract and unjust enrichment, but in the complaint, it's silent, it's not here.
That's correct.
All right, thank you.
Thank you.
Good afternoon. May it please the court. My time is scarce, so I'm going to go through some of the main points. I actually didn't hear anything that I really need to respond to, quite frankly. I think the court is correct in that the statute is silent on private cause of action.
So what element of a breach of contract does not appear in plaintiff's complaint?
What element doesn't appear?
Does not appear.
Well, I don't think he pled any of the elements. I mean, he's saying he pled the facts, right? So anytime you make a purchase, there's an offer and acceptance and there's a consideration. But he just had the facts. So if you want to try to fit those facts, I'm going to make the argument for him to try to fit the facts into the elements. I mean, you could argue that, yes, all the elements are satisfied by the facts alleged because you made a purchase. There's an offer. Something's offered for sale.
Well, when he argued that in the lower court, in the motion court, you didn't oppose it making this argument, did you?
He actually didn't make the argument that it's breach of contract. In the opposition to the motion to dismiss, it just says, well, even if the cashless ban is enforceable by the department, there's still a wrong here, and there's still a breach of contract, and there's still unjust enrichment. So that's one paragraph right at the end, almost a throwaway, said in passing. It certainly is not an argument advanced to say, yes, the elements of breach of contract claim are all in the complaint and adequately stated. I mean, this certainly wouldn't be an argument. I would say there was an assertion that there's a wrong here and breach of contract is an appropriate remedy for it. But with respect to, there's a liberal standard for a motion to amend, but he didn't make the motion to amend. I'm sorry, a liberal standard to amend the complaint, but the motion wasn't made.
Do you have a claim here if you don't have the statute?
Yes, you do have a claim, and the claim would be a breach of contract. And if the court is determined...
Before this law was adopted, would you think that the fact that you're not giving coin change constitutes a breach of contract? I mean, this statute was adopted because there was a perception that there's something happening which shouldn't be happening, and we need a new law to deal with it. Absent a new law, there wouldn't be...
Right, but that's a hypothetical, but there is this cashless ban, and the claim was brought under the cashless ban. It doesn't provide...
And if you paid by credit card, you'd be paying the exact amount.
Correct. And so in that hypothetical, without the statute, what would be the remedy? Yes, it would be a breach of contract, and I think somebody would actually have pled it and would have pursued that claim. That's really not the claim being pursued. But in that hypothetical scenario, yes, that would be the remedy that a plaintiff could possibly seek. But I would say that in this instance, if you're talking about less than $1.64 for 3 claimants, there's a de minimis doctrine.
But that's precisely why we have, one of the many reasons that we have class actions. So he moved for a class action certification, so that addresses the de minimis argument.
Well, no, we're not at the certification stage. We're at the pleading stage. Before then, you have to adequately state a claim.
Please don't talk over her.
The complaint alleges a basis for class certification, and that would address, the complaint did that, whatever else it didn't do, it did address class certification. If you have class certification and there are thousands of people who go to this restaurant or restaurants like this and don't pay and who pay in cash and don't get any change, the numbers add up.
Sure, and I apologize for speaking over you. I think it addresses class certification the same way it addresses a breach of contract.
No, it's actually more specific about class.
Well, it's pled as a class action.
Yes.
Right? Absolutely, but I'm saying you have to adequately state a claim before you get to the certification stage. We're not there. That's all I'm saying.
Thank you.
If there's nothing else, thank you.
Unless the court has any questions, I'm prepared to...
Going to submit?
I'll submit.
Okay, thank you.
Thank you, judges.
Williams v. Williams.
Good afternoon, Your Honors. May it please the court. Lily Pollack from the Price Law Firm for the defendant appellant Gary Williams. The Supreme Court, in its decision below, improperly ordered the forced sale of a family cooperative apartment while completely bypassing the mandatory protections.
If we were to agree with you that there should have been a settlement conference, correct. What should happen here?
It should be remanded, and the court should order that a settlement conference take place. The court should not have considered this motion for summary judgment at this stage. The settlement conference in itself was required. At the very least, it should have been required for the court to make a valid determination based on the heir property classification, which in our brief, respectfully, it's asserted that it is clearly heir property. It meets all of the elements to be considered heir property and thus to fall under the Uniform Partition of Heirs Property Act. And at that point, then, as soon as RJI, a request for judicial intervention, is filed, a settlement conference has to be scheduled, and any motions are stayed and or held in
Given what's
abeyance.
already happened in this case, if we remanded it, would they simply start over or have a settlement conference and then see what happens from there?
Correct. We would ask for the settlement conference to be scheduled, and there is a requirement under the law that the plaintiff, in this case, engage in good faith, actually, it's both parties to engage in good faith settlement negotiations. Yes, both parties to engage in good faith settlement negotiations. What we have here is a forced sale that is going to strip one individual's of their family home by forcing the sale. What a settlement conference can achieve is coming to a resolution.
It's the home for both parties, right? It's a
Correct.
family home. They both inherited it. It's not just the property of one individual.
It's not just owned by one individual, no, but one individual has lived there exclusively by himself for, at this point, 12 years.
Arguably after ousting the other.
I can address the ouster finding, which we don't believe was properly proved as a matter of law on the lower court, but
as stated. The lower court
Couldn't it just
effectively
send-
rewrote the
couldn't- Couldn't
statute
it
by,
just be sent back for a settlement conference and everything else stays the way it is?
no, we would ask that it be set back for,
I understand what you asked, but why couldn't we do that?
I guess I'm not entirely clear on what your question is in terms of what would stay exactly as it is.
What would be wrong? What would be wrong if we said go and have a settlement conference, but otherwise we're leaving whatever happened below the way it is?
Well, for starters, we believe that the ouster finding was improper, and even if there was an ouster finding by some stretch, the court did not take into consideration that the defendant had lived there by himself and paid every single expense, every common charge, every carrying charge, every maintenance charge for 10 plus years.
So he may
their
owe rent.
determination.
He may owe rent to the other tenant.
He may owe rent.
Owe rent, yes.
He paid it all. He did not.
No, for use of the property that was was hers as
essentially,
well.
but it wasn't considered by the lower court and it wasn't addressed in their decision at all. And the fact that the lower court just bypassed the entire provisions and the protections of this act because they found that the will was some sort of binding document in terms of a partition agreement, completely negates whatever the subsequent bindings were. So we asked that it be remanded and restored for complete compliance with the Uniform Partition of Heirs Property Act.
And the Heirs Act would also call for, as I understand it, setting of an appraisal of the property before it's put on the market, unlike in a usual partition action.
Correct.
Thank you, counsel.
Thank you.
Thank you. Castleman v. Interactive Brokers. Justice Chan is recused.
Good afternoon. May it please the court. My name is William Moran of Otterburg. I represent appellant David Castleman, the federally appointed equity receiver for E-mini FX. The Supreme Court's decision below was an error because it relied upon the Court of Appeals in peri delicto analysis in Kirshner versus KPMG for its basis to dismiss the receiver's claims against respondent.
So can you distinguish this from Kirshner?
This case is distinguished actually in three very salient reasons. Kirshner was a litigation trustee appointed under the plan of bankruptcy, and as such was precluded by Section 541 of the Bankruptcy Code for bringing any suit that the corporation could not have brought pre-petition.
In this case, you're seeking to have the receiver assert claims on behalf of the corporation, right?
Actually, by virtue of his being named a equity receiver by the federal court, he is now he becomes the custodian of the claims, which is how the Eighth Circuit.
Who would those claims belong to?
He represents E-mini FX as the receiver. He becomes, however, the custodian of the claim, so he brings the claims.
But as a custodian, you're holding something for someone else.
For E-mini FX, yes. For the
corporation.
The corporation.
The corporation who the sole owner of that corporation was the individual involved in the wrongdoing.
The sole owner, but not the sole manager. And as said in the Williamson case, you can't just ignore the facts. And the facts are, we've alleged that there are other managers who were named in the complaint that may have interfered with him, which is why he kept it from them.
Could the corporation assert these claims, or would they be barred?
Well, there is no, at this point, the second.
At this point, they can, but.
At this point, well, the receiver threw
Are these
out
claims
all
that
of
the corporation could assert?
I'm sorry?
Are these claims that the corporation could assert?
Right now, there is no corporation. So
Had there been a corporation, could the corporation have asserted the claims?
Before he was named as a.
Right.
Well, that would be a completely different situation. I mean, what we're dealing with now is he's been named as the receiver, and as such, he's the custodian of the claims. He brings them.
So the corporation couldn't have asserted the claims.
No.
If they couldn't.
Just want to go back, because you're talking about Williamson, but I'm not sure how that applies here, because number one, it is before Kirshner, and it really focuses on, a fraudulent conveyance claim, seeking to claw back the funds. I don't.
Actually, Williamson, the case was about an audit and claims against the auditor, the malpractice of the auditor. And the judge decided not to apply the imperi delicto defense in that case and let that claim go forward. It wasn't just for fraudulent conveyance.
So, turning again to Kirshner, I couldn't find any cases that applied the in pari delicto analysis to any plaintiff that was not a bankruptcy trustee or appointed in some way connected with the
That's
bankruptcy
correct, Your
court.
Honor. And
Are there any cases that apply Kirshner to anyone, any kind of receiver other than a bankruptcy receiver?
Not that we found, Your Honor, and with Kirshner really just applies to bankruptcy as opposed to what we are, which is non-bankruptcy receiver who's bringing claims on behalf of the innocent shareholders or the innocent investors in this case. And this is their way to get their restitution. This is how they go about doing this. And the third reason why—
I assume the theory behind appointing this person is that that person would be able to bring lawsuits, not that he would be deprived of standing.
it's specifically stated, and he's given authority specifically by the order of the court, which is, again, a court in a regulatory proceeding, which is brought by the CFTC to protect Americans from fraud, which is why the receiver is bringing the claims on behalf of these people to try to get them restitution.
And is he in any sense a receiver connected with the corporation, with M&E?
Not at all. Not at all. In fact, he's thrown everybody out. There's nobody, no wrongdoers left. This is a completely cleansed company now, which makes a difference.
But it still exists as a company.
I'm sorry?
Does it still exists as a company?
The company is still in existence in the hands of the receiver. And the receiver's sole function at this point and the sole business of the company is to get restitution to these innocent victims of a crime. And another area I just want to touch base with before I finish is that this is a threshold issue. If you decide that imperi delicto does not apply, we don't get to the adverse inference exception. We don't get to the sole actor exception to the exception. But even if we did, we submit that we have enough in the complaints to meet those burdens. In addition, we have enough in our complaint to state a claim as opposed to what my adversaries have said.
Thank you.
Thank you.
Good afternoon. May it please the court, Gary Mennett for the Respondent Interactive Brokers, LLC. First—
Counsel, I'd like to ask you the same question I asked your friend there. Are you aware of any cases applying Kirshner outside of the area of bankruptcy trustees? I couldn't find any.
Yes, Kirshner itself was answering, the Court of Appeals was answering two certified questions.
I understand, but it was addressing a question related to a bankruptcy trustee.
That was the question from the Second Circuit, but they also addressed a question from the Delaware Chancery Court, and that question was a derivative plaintiff action. And so the Court of Appeals said that this rule, imperi delicto, applies to any fiduciary. They applied it not just to the bankruptcy trustee, but also to derivative claims, because
now, back to the question I asked you. Are there any cases that have applied that principle to any plaintiffs other than appointees of a bankruptcy court?
In
New York?
In New York, Kirshner itself.
Apart from Kirshner, is there anybody who's applied Kirshner?
No, Your Honor. For the most part.
Imperi delicto means essentially that courts should refrain from intervening in a dispute between two parties at fault.
That's
but
correct.
The plaintiff in this case isn't at fault in any way, right?
Oh, no, but they are, Your Honor, because the plaintiff in this case can only, all of the rights that the receiver has, the receiver, of course, himself,
Because
Mr. Castleman,
to the
he's not
extent that
guilty of
they're
anything.
individuals in the corporation that might have a claim, they can't assert them against the defendant because they're not in privity. Is that correct?
That's correct.
So now,
Mr.
if you're talking about corporate claims, the corporation couldn't assert them because they're not entitled to assert these claims under pari delicto. So now the question becomes, so because you've appointed a receiver, does the receiver have the right to assert these claims on behalf of entities or individuals which don't have a right to those claims?
That's correct.
Is that what this case is about?
That is what this case is about. And Justice Gesmer, that is what the Court of Appeals said in Kirshner. They said,
I know what the court said.
They said,
Kirshner. Thank you. I read it.
before Kirshner, obviously there was grounds for dispute about that, but Kirshner in New York is the law.
Well, counsel,
and
what—
Kirshner says that the receiver only has the rights that the entity has. And
it was primarily addressing bankruptcy receivers who are bound by Section 541 would give them that.
But Kirshner specifically
limit their
says—
rights to those of the corporation.
But Kirshner specifically says on page 476 of NY3D, 15 NY3D, that it also applies to similarly situated plaintiffs. That is a direct quote. And
right. I guess my question is this a similarly situated
It is.
plaintiff? Because this plaintiff, for example, is not bound by Section 541, which limits a receiver in bankruptcy only to claims that can be asserted by the corporation.
But the federal statutes under which the plaintiff is appointed, they say exactly the same thing, and we cite those in our brief. So the federal statute, 28 U.S.C. 959, says a receiver manages and operates the property in his possession in the same manner as the owner. He cannot get more rights than the corporation had. And since the corporation...
Is the principle that the fact that you appoint, whether it's a trustee in bankruptcy or a receiver, that person doesn't get more rights than the entity or individual on behalf of whom they're seeking to assert a claim?
That is exactly correct. He gets the same bundle of sticks, that the corporation had.
What
no
about
more and
this
no less.
idea that the corporation has now been cleansed of all the bad actors, and so the operation is on behalf of these innocent individuals in the corporation? Does that matter?
It does. Of course, it matters in some sense, but it does not matter to the application of impari delicto, because although there's no dispute that Mr. Castleman had nothing to do with the fraud here, what he has the right to do, standing in the shoes of E-mini-FX, is only exactly the rights that E-mini-FX had, and E-mini-FX was controlled 100%.
Even though he was appointed as an independent receiver, does that change the analysis under the application of the doctrine?
It does not, because again, under the statute, the only rights that he has are the rights that the corporation had.
I don't think that's what the federal court thought when they appointed him, is it? It seems to me that the order of the federal court is much broader than that.
The order of the federal court is pursuant to the federal statute, and the federal statutes do not provide him with any rights beyond what the receivership property had. The statutes.
Now, do you agree that impari delicto is an affirmative defense, not a standing issue?
It is an affirmative defense.
And that's what Kirshner
New York.
says.
That's correct. But Kirshner also says it can be appropriately resolved on a motion to dismiss. And in fact, in Kirshner, both of those certified questions were on pleading motions. In addition, the one other case that I want...
Is there anything in the order that lends us to the analysis that the judge decided this based on a standing issue versus an affirmative defense issue?
The trial case?
No. The trial court relied really on Kirshner and 546-552 West 146th Street versus ARFA. Judge Friedman was on that panel. That's First Department 2008. And in that case, what the court said, that was also on a motion to dismiss, and there what the court said was that where the fraudster, here Mr. Alexandre, owns the entity 100%, there is absolutely no defense to imputation, and the corporation is charged with his fraud. Here, the receiver stands in the shoes of the entity E-mini-FX.
Thank you, counsel.
Thank you.
Well, first of all, we disagree with the point just made that if it's a sole owner, he's completely barred. The question.
What do we have in the record to suggest that it wasn't a sole ownership?
That's right. Well, it wasn't just a sole ownership. There's also other managers, and that's the point I was trying to make. It's not just whether or not it's a sole owner. It's also whether or not it's a sole owner or a sole manager. And there were other managers at the company that he was trying to hide this from, and he was specifically trying to keep this from because they may have been able to interfere with what he was doing. Also, I'd like to just respond to the question of who are similarly situated plaintiffs. I would submit similarly situated plaintiffs would be other bankruptcy fiduciaries. In that case, it was a litigation trustee. It would be a Chapter 7 trustee, a Chapter 11 trustee. Those would be similarly situated plaintiffs.
How is it that as a receiver for the corporation, right, you're permitted to do actions that the corporation itself could not do?
The plaintiff appellant is operating under the court order, and which specifically authorized him to bring these claims this specific claim in particular, to try to enlarge the amount of
You
money that
authorize it if he has a right to bring the claim. It doesn't mandate that the claim be brought if it's otherwise not a correct claim.
And we submit by virtue of the state law and by the court order itself that that plaintiff was in fact authorized to bring these claims.
All right, anything else? Thank you so much. Marinick v. Marinick.
Good afternoon, Your Honors.
Good afternoon.
This began with a woman named Alexandria Lipton, who was discharged for cause from my matrimonial case in April of 2023. 2 years later, she filed unearned fee claims against multiple former client victims of hers at around the same time. My judge was the only judge who signed her order to show cause and allowed her into my case, where she has now remained for 1 year and 3.5 months, causing additional litigation, delays, expense, and chaos in my matrimonial case where she does not belong. So the result of this is that there was an unlawful, non-consensual reference in a matrimonial action that had no statutory basis from its inception. Later, it was terminated by operation of law, and yet it was still improperly treated by the court as a valid and active reference. The controlling statutes and the rules are mandatory, yet they were repeatedly ignored and continue to be. CPLR 4212 states that there cannot be a reference without consent unless there is a showing of some exceptional condition, and the order shall specify that exceptional condition. The April 29th, I'm sorry, I was hoarse. The April 29, 2025 order of reference contains no such findings. Section 202.43D of the Uniform Rules further states that an order shall contain language providing that if a trial has not begun within 60 days, the reference shall be canceled and the matter shall immediately return to the court. That mandatory language is absent. No hearing commenced in 60 days, and yet the matter was never returned to the court. Judiciary Law 487 states that an attorney guilty of deceit shall be liable for treble damages, and the Court of Appeals and the First Department have repeatedly confirmed that Judiciary Law 487 addresses intentional deceit, not malpractice. Yet the February 2026 order reframed Judiciary Law as malpractice, Judiciary Law 487 as malpractice, while also bypassing longstanding Court of Appeals precedent holding that discharge for cause forfeits fees as a matter of law. So again, the governing statutes and controlling precedent are settled, mandatory principles repeatedly ignored throughout the proceedings. I respectfully request this court a vacature of the February 9th, 2026 order and the April 29th, 2025 order of reference, together with remand for full judicial determination before an impartial justice.
Thank you, and I gave you an extra minute.
Thank you.
Okay.